who was evicted from her constituency accommodation, my lords, by local officials, the additional district magistrate and the district magistrate, in the dead of the night at 11 p.m.
High Court.
My lords, this requires, my lords, in our respectful submission, some comprehensive directions, because it involves, my lords, this involves issues of federalism. It also requires an independent investigation. And this has happened, my lords, despite the High Court already having passed protective orders. So this is happening despite, my lords, I'm only praying for listing on an early date, because this involves an important constitutional issue, my lord.
Please keep it yourself. We are not going to entertain.
Lords, I'm just putting a matter for kind consideration of this Honorable Court
My
regarding
lords,
that 20th July Jantar Mantar protest. I'm just seeking, my lords, I'm praying my lords to take sumo to cognizance of only one aspect. The matter is already seized with my lords. Where the sexual assault, where the girls are claiming that they have been sexually assaulted in terms of maybe lathi was jabbed into the buttocks or some other instances which are so heavily reported on social media. I am beseeching my lords to take sumo to cognizance.
These are subject matters of repetition themselves.
My lords, these are the instances.
Independent writ petition was filed.
Allow me
with
to-
regard to alleged violences on the basis of.
Allow me to complete the submission. I'm requesting my lords to take stand alone the sexual assault cases, to constitute, my lords, maybe not a committee, but appoint a district judge, designate someone so that the girls can actually send their complaints directly, and those sexual assault cases can be taken up.
Madam Shobha, in the order which we have made reference to the committee, this issue is specifically mentioned. This is specifically mentioned. Number one. Number two, priority basis. So in the two issues we have requested the committee immediately take cognizance and to submit an interim report. You may be justified.
My concern is about how would the committee is going to get the complaints. An order which says that they can, an email ID is provided, a designated officer is designated, to whom,
So what we will do, we
and it is given a publicity that
We appreciate your concern. In the order, we have permitted the chairperson to appoint a nodal officer, a judicial officer as a nodal officer.
my lords, please.
We will see that if they have appointed, then we can send a message to the committee to notify, so that all those who have grievances, they can at least
Directly.
directly submit their complaints to the nodal officer.
That's my precise concern. The instances to reach to the committee. I'm so very grateful. I'm so very
My
grateful.
lords,
Square that, take care.
I'm so very
my lords, my only request was that my lords will just kindly examine it. My lords may just kindly examine.
Malaj, if I may just request for a reconsideration of this eviction matter, Malaj, because it's proceeding with, Malaj, the SLP may become infructuous, Malaj. On 17th, the order was uploaded. We filed the SLP on 22nd.
It's only to create hype in court, that's all. We are telling tomorrow that there is a huge rush of matter. Please wait for, we will list your matter 31st, first, whenever you want.
Deeply obliged.
Give the details, we will list it.
Deeply obliged.
Your Lord, may I mention anticipatory matter, my lord? That anticipatory bail matter, my lord, that was dismissed by the Honorable Patna High Court, my lord. But ultimately, my lord, that order was passed without looking at the affidavit filed by the state, my lord. My lord,
You are seeking anticipatory.
anticipatory, my lord, because the entire dispute is regarding the registration on the documents.
Have you filed your petition here?
Your Honor.
You have filed SLP.
Yes, Your Honor.
You have cured the defects.
Yes, Your Honor.
It's ready for listed.
Yes, Your
All
Honor.
right, tomorrow.
My lord, deeply obliged.
There is one third mentioned.
But there is a IA has been filed by us, my lord.
My lordship may kindly permit me to mention, my lordship, there is an SLP which I have filed. My lordship, the urgency is that a recovery is ordered, my lordship, of 6.7 lakh rupees, my lordship, commencing after 1st of September, my lordship. My lordship, I have cured all the defects and court fees, my lordship, but the scrutiny section has held up the matter since the last 1 week, my lordship. So, my lordship, my humble prayer, my lordship, is,
What is the urgency?
my lordship, even a letter of urgency, my lordship, I have submitted to my lordship's esteemed office. My lordship, on Saturday, my lordship, the letter is,
I think 2 days back also you had made a mention.
my lordship, grateful, my lordship.
This was adjourned, awaiting indoor development.
It will be covered, I think.
Yes.
Are you appearing in item one?
Please, Milord.
I am appearing
Respondent,
on-
Milord, the petitioner has filed an early hearing, Milord.
Hmm?
The petitioner has filed an early hearing.
Early hearing.
That's an early hearing application, my lord. Because, my lord, kindly see in the early hearing application, page number 6, my lord. This matter may be listed after the Indo development matter, my lord. It is not listed, my lord. I am just requesting.
Now it seems to be covered by the, alright, list on so, so list in the miscellaneous, things.
Oblige, my lord.
For the state of Tamil Nadu. My lord. Yeah. Item 2 is also an application for early hearing matter.
Malads, I appear in this matter, Malads. It's an early hearing matter. There are officers, manager of the railway coach factory, who have been accused of negligence and being complicit in an accident which happened completely inadvertently. And Malads, sanction was refused by us, which has then been challenged. Malads, at any date, Malads may hear this because, of course, there are officers involved and
The problem is that in how many matters there is already a stay in your favor.
yes, but Malads, nonetheless, Malads, these are officers and the sword of Damocles is on their head. And when we don't think that they're involved at all, and we refuse sanction, but nonetheless, it's been challenged. Any date, Malads, at any date of convenience.
So 6 months.
Obliged.
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 Please, Manoj, this is my early hearing application. I'm only praying for any, subject to convenience of my Lord, any date of mistake.
Wait for some time, please, and I think at 2023
He's
appeal.
retired, all the emoluments. In fact, before passing of
Yes,
the
yes,
stay order, Manoj, was been listed in September sometime, Manoj, any.
Item 4,
May I please, Your Lordships? Lordship, this raises a very serious issue when it appears that private companies are actually selling private personal information, which includes not only my employment history.
We have some other issue also regarding.
Lordship, the shocking part is that actually advertising that they have access to the EPFO records and the ITR records.
consider your presentation.
Would your Lordship consider issuing notice, so the state can also, because what we have done is we've written to the state.
Otherwise, what will happen, so many.
We've already written to the authorities. We've given two representations to the union government.
Direct them to consider that presentation, take a call on that.
Lordship, my only concern was if it would be under the aegis of your Lordships, it kind of has gives it a little more impetus. That's it. Because ultimately this is thousands and crores of people's personal data, which is being sold at paltry sums. 200 rupees for my ITR returns.
Some architecture has to be developed by the digital repositories under the DPDP Act.
Lordship, something is fishy here. Why I say that is because what is happening, I have my learned friend here, she has personally, I'm so grateful, Lordships. Lordship, would your Lordship consider meanwhile,
Probably get a solution also. You
We
have
may-
prepared a detailed representation. It's better that we get a time-bound consideration for that instead of, then what happens is this writ is there. Then it goes on, notice comes, and by the time it is taken up and decided, you would have got the relief also.
What question is of
Seriously,
effectivity.
if you want a solution.
It will make a news item, but that's all.
may I make a suggestion then, your Lordship?
Yes.
Your Lordship
It approves
may
the
direct the
authority.
government to hear my representation, deal with it and come back to your Lordship.
That
At least a
will
time-bound
take
manner.
time that I- yeah.
Let it be pending, your Lordship.
But see, madam, this is absolutely core policy.
I bow down. I am not disputing that.
Stakeholder consultation, experts to be appointed, body to be considered. Now, we are conscious of our monitoring powers.
May I just make one submission to just,
Monitoring actually is a very labored exercise.
Your Lordship, I bow down. My only concern here is my learned friend here has actually undertaken the exercise of actually applying to all these private organizations. She has actually given applications and received information of her own friends, of ITR
You have
returns,
sent-
of
You have sent it on 21st March.
Lordships.
Give them some time. There is not a single issue. This is not one issue with them.
Yes, Your Lordship.
Give them some time, let them consider. We will pass that order that expeditiously it will be considered not, maybe within period of 3 months or so. Let them come out. Otherwise, your writ will be opposed on the issue of maintainability.
I
Then
am not,
it
Your Lordship,
never
I am
get-
not, this
Only
is not
it will
adversarial
be
at all.
pending writ
Yes.
For you, that's all.
I bow
This
down.
may actually resolve your genuine concern. You
Yes,
have
Your
made a very good representation between 61 to 82
Absolutely.
page numbers.
These guys have worked very hard and they have
Yeah.
actually come out with
Corrected data.
action which is
Maybe the authorities are not, their attention is not yet drawn to that.
Lordships.
It's a very good exercise you can do.
And would your Lordship consider directing the union government to
Yes.
consider, but keep this pending, may not issue notice, keep it pending. Because we would want to come back to your
I won't
Lordship.
consider if the matter is pending.
We would want to, your Lordship, come
Also,
back to
no.
your Lordships.
Actually, if they consider, get a fresh, if there is no, not addressed, you will get a fresh cause of.
We'll come back then, your Lordship.
Yes, sir.
We'll do that. That's what they're saying. They will consider representations in a time-bound fashion.
So. Okay. Dispose.
Resolution Article 32 has been filed in public interest, seeking court monitor forensic audit and safeguards against unauthorized private access to stock ITR, recurring on internet data used for employment verification. The petitioner has averred that an unregulated private employment gas verification ecosystem has emerged. Where some private entities for access where the private entities for access increase and
They don't deal with, you can come back here again.
commercial use of sensitive employment and financial data. We said data corresponds to the report maintained by the Income Tax Department and Central Board of Directors, Taxes. The petitioner has rubbed the two instance, highlighting that between appeal to control and media. But we will claim to like to a broader private verification ecosystem. It shows that the private entities, including a Plexigo technologies, describing data fetching, describing themselves as data fetching and verification capability, highlighting their data fetching and verification capabilities. In some substance, the petitioner's case is that there is an illegal, unauthorized misuse of the private data of the individual by these entities and thus sensitive statutory data is being accessed outside the protected governmental ecosystem. This unauthorized exercise is alleged to be violative of Article 21 of the Constitution. It is also alleged that data collected for sovereign functions is being repurposed for private commercial streaming. Consequently, the petitioner has sought into earlier the following direction. That's why, in this regard, we find that the petitioner has submitted a very comprehensive presentation. Comprehensive representations dated so and so. 21st March 2026 and 22nd April 2026. So the official respondents, copies whereof have also been placed on the court. So since the issue involves policy intervention by an expert committee, on the recommendations of an expert committee, we dispose of the petition at this stage with the direction fee. The Union of India and other official respondents to consider the representations by the petitioner and take necessary action as is required to prevent misuse of the data collected by respondent, collected by the data maintained by Income Tax Department and Central Board of Directors in exercise of the
And if you want a conscious selling, you can deal with the government and other authorities.
collected by so and so in the EPFO passbook API and Form 26 AS API and take such necessary measures as may ensure that such data is not misused or unauthorizedly, is not unauthorizedly otherwise misused by the private entity. It will be appreciated if a comprehensive decision is taken and communicated to the petition, preferably within a period of 4.
I'm so grateful, Lordships, obliged. Deeply grateful. 4 minutes.
My pleasure, Lordship. 25th September 2025, the interim order was passed.
From time to time,
There,
there is pending.
matter is pending.
The petitioner authority initiated a tender process for development of a dedicated south container for at Pradeep Port on a build-operate-transfer basis through a public-private partnership. Respondent 1 and 2 also withdrew, but wide disqualification notice dated 10 September 2025. Their application was rejected and categorized as inverted commas non-qualified. The agreed private respondents have appealed to High Court of Odisha through petition number 26886 of 2025. The High Court passed itself between interim order dated 25th September 2025, restraining the petitioner authorities from proceeding further on the basis of to proceed further pursuant to the tender process. That order is now being challenged before us. That's why it is not in dispute that the matter is still pending before the High Court. What is the next date?
Next date is not coming, your lordship. Last it was listed on May. That day it was not also taken up.
We are informed that last time the matter was taken up in May 2026. Absence finalization of tender has been stalled. We request the High Court to take up petition number 26886 of 2025 and decide the same at the earliest. This point. We can't direct the High Court anything, we can only request High Court.
Your lordship, some time.
It doesn't look nice.
It says a national report as the container berth, your lordship, that only in this eastern region, there is no container berth.
You produce this order, you have also taken more than a year now, almost.
To come here, 8 months below.
Your lordship, please, some time, your lordship, request.
It doesn't look nice for High Court that we tell that you.
Preferably what, your lordship?
At the earliest we have used the word.
Preferably 4 weeks or something like
We have
that.
used the word at the earliest. Please go and submit it.
Your lordship, this side or that side, your lordship has the, deeply obliged.
Item 6, there is a.
Deeply obliged.
Item 6. Letter has been moved by any.
Yes, item 7.
That's 7 of OBC.
7, my lordship, the connected matters coming up. I think this is.
7.
मुझे पता है जो सर there is a development after with, I'm sorry.
As far as item 7 is concerned, your lordship's order where Mr. Mehta withdrew the petition says that the withdrawal shall not preclude any other affected person from approaching this court in accordance with law. So this court, now, my lords, the question still has to be decided whether when you include people with the Backward Classes Commission's recommendations, can you just withdraw the notification without the Backward Classes Commission's recommendations? Now, the High Court did a hands-off approach saying that this matter was pending before your lordships. Your lordships have subsequently disposed of the appeal at the request of the state of West Bengal, leaving it open for us to approach here. Now,
of course, option now is that we request the High Court now decide the case on matter.
now the development that that the solicitor was probably saying was the fact that the High Court has now, in another matter, not my matter, decided it.
No, I'm not, I was not going to say. I was saying to say some other decided, a particular decision was taken by the High Court, which was before your lordships, which was withdrawn. After withdrawal, the government has issued a notification reverting the original reservation back.
This notification, in fact, is in terms of the High Court's first judgment.
First judgment, your lordships are right. That can be challenged here. I'm not,
First judgment may be challenged, as well as the first judgment was in challenge at the behest of the state. The state having changed its policy since then.
But I'm not.
To withdraw.
But I'm not.
Parties may come and challenge that. Have any party challenged the judgment?
The subsequent withdrawal by the state government was challenged before the High Court subsequently. A judgment was passed and they have filed an SLP which is currently lying in defect. So that
I may make it clear, I am not arguing
There is
that
no
this
point in
appeal.
going back, you mean to say?
Yes, there is no
Because
point
it's
in going back.
taken by the High Court and.
Yes, I am not.
This has to come along with that.
This has to come along with that.
Ma'am, Your Ladyship, I'm sorry. Lord, I'm not raising a
Give
contention that against the original judgment which was impugned in my
Status report
SLP
copy hai?
cannot be challenged. That's not my case. It can be, it has to be challenged only here. My Lord, High Court cannot now take a re-look at it. I just wanted to say there is a subsequent factual development, that's all.
You mean to say the basis has gone, so if they have to challenge, then the old is now back, so therefore they may have to lay a fresh challenge if at all.
Well, what, my Lord, I can't say what.
Number of that other.
That, yeah.
Then
I
we
mean, I've
list
just
both
passed it
cases.
on.
Well, list both, so unfair case.
Your lordship is posting this along with that,
Both cases together.
both the cases together.
Very technically, you have to challenge the original. law.
We may have to file that also.
Otherwise, you stand exposed on res judicata.
No, even otherwise the basis would have gone.
With great respect, my lords, your lordship is right, but there is another way of looking at it.
You
That-
may look at.
The subsequent withdrawal.
Use blinkered eyes to look at things.
No,
but
not
it's
in
better to
blinkered
look
eyes,
with open eyes.
lawyer's eyes.
What it stands today is what.
Your lordship opens both eyes and Shiva's third eye. That I'm entirely aware of. But the point is this, my lords, that even if they had to withdraw it.
It's your baby.
No,
How
of
to
course.
handle it is your.
I'm sorry, my Lord, only
The more
one,
notification, the better it is.
one
for-
clarification. Shiva used to open his third eye when Lord Shiva was angry. Lord, your lordship.
That of course, that of course.
So the
by-
simile, my lord, may not be true for this call.
No, but if we get into theology, my lords, Shiva's third eye, there were Mohinis also who could sort it out at times.
Yes, sir.
And
Anyway,
They are all persuasions, and that is coming
Yes.
from the other end. Whenever intellectual and knowledgeable persuasions come from the bar, the third eye of the judge opens.
That's a trigger.
that's true.
Point.
That's true.
No, they're tagging it. Oblige.
Policy remains changed today is what to get to.
Yes, the policy having been changed, but they can't do it without the backward. We will file another petition also, my lords, that.
Whatever.
Obliged.
Please, my lords.
Lordships, item 8 should preferably be taken up along with item 50, which is a batch of petitions relating to Mahira homes.
Item 50 can be taken
So
up now
item 8
because
is
Fresh matter, right?
the same.
Item 8 is in fact, Leonard Amicus's report was pending in all these connected matters. I appear for Mahira Home, Lord. We have filed our responses. We have given our plan how to complete these projects to the Honorable
Who is going
Amicus.
to trust you, Mr. Uda? The kind of, the credibility of this builder, who is going to trust you? Who is representing the home buyer?
I'm representing the home
Item
buyers in item
50.
8, my lord.
50.
Item 50.
In any case, my lord, the amicus's report has to come. We will also have a look at it. We will make our submissions on the basis of whatever is the report, my lord.
There is no need of report or anything. You just give a factual note, Sujan.
We have made detailed submission pursuant to my lord's order that you give whatever proposal, whatever financial things you want to give, you give it to the learned amicus, and amicus submits the report like in all other builder cases. Amicus report has been submitted. My lord, then we also get to know that.
I've made a summary of the factual aspects
And
of
Lord,
this.
we
batch of
also get a
petition.
copy, and my lord, grant us some time to go through these summaries, my lord, which have been prepared, because
This batch of petitions, your lordship.
Who is representing the home buyers in item 50?
My lord, I am in item 50.6 and item 8. For item 50, the main matter.
Of course, you have challenged with all allegations against this builder, we understand that.
My lord.
But what is the via media? What is the solution?
My lord, we are before your lordships, my lord. The learned amicus is prepared.
Very fine, but we have to find out some viable solution.
Please, my lord.
You are not going to trust this builder.
My lord.
This
My lord.
project was launched which year?
I'm sorry, my lord.
This
These
project was
projects
this
were
was
of
in
2017 to 21.
and
Five
my lord,
different
supposed to be
projects.
complete.
They were supposed to be completed within 4 years. of
somewhere, my lord,
the
22,
completion.
23,
4 years of the
24.
approval of the building plan. The first building plan was approved in 2018, your lordships. So the expected date of, scheduled date of completion was 2022. in respect of the first project.
And my lord,
in
we
sector
will, my lord,
68.
grant us
that's
opportunity. We
the
will explain that why it could not be completed in 22 or 23.
Prayer and
So, my lord, today,
My lord.
So your prayer is to send it to MB.
my lord, in
My
fact,
lord, one of
we
the prayers-
volunteered. My lord, in
NBCC
fact,
or
we volunteered to say,
Trust you. You have already duped them. Your entire money has been siphoned
My
from these
lord.
people. Who is going to trust a builder like this? The question is that if they have already taken your money,
My lords.
siphoned it somewhere else, how MBCC will complete?
My lord, NBCC has also given certain proposals. I'm sure the learned amicus curiae has also given some options in the learned amicus's report. That's something that we still have to consider.
You just examine this angle. How to make this project viable?
I'll do that.
Is there any, like, MBCC is probably a government of India entity.
NBCC is a public sector
Is
undertaking.
there any public sector entity who can also be?
There are some others, for instance, Engineers India Limited is also into kind of group
Engineer India Limited is
constructions.
also a credible name.
Madam.
And probably in Gurgaon side, they have done some projects.
Yes.
On the highway, when you go, I recollect one of the projects by them. I'm not sure about residential or commercial, but one of the projects is by them. So maybe that these, some government entities need to be, this is affordable scheme.
This is an affordable housing scheme
Haryana.
of the Haryana. state.
affordable
These are
housing,
affordable housing schemes.
affordable housing scheme.
Affordable house, the state is creating all mess. Why, how they grant license like this and when they refuse to monitor everything? The rate is fixed by them, license is granted by them, the rate is, everything is done by them and then they suddenly disown. Now, only way out is that on what terms and conditions they will be
So,
willing to complete these projects. We can continue to have a court monitoring, whether it is MBCC agrees or any other government entity agrees. You please explore that part also.
I'll do that, sir.
And,
Lord, may I suggest one thing, my lord? In a bail application, one of the owners, my lord, the builder, the ED had filed a reply. ED had come out with a solution. If the amicus can look into it, what is flowing from a lordship is probably has already been taken care of by the ED in that reply.
how
Yes.
it is going to
For
cost?
reconstruction, I mean, the construction.
Yes, they have come out with a proposal, my lord, and that it can be released and it can
We
be
are
done.
concerned about,
with-
since when ED has
The amicus can
started constructing
assist your lordships. I'm not saying, lord, I am for a home buyer, my lord. I'm for a home buyer. We need a plot, my lord. So amicus can, my lord, look
What was
into
the
that.
rate of allotment? What was the rate of allotment?
Rate?
My lord, in
4,000 rupees per
4,000.
square feet.
4,000.
That was,
square
that
feet.
was a rate determined under the affordable housing scheme.
If
Currently,
amicus
the
can-
rate is 6,000 per square feet in Gurgaon.
If amicus can look into it, my lord.
Also, we are only telling you practical solution.
Please,
And
Lord.
people also be reasonable.
We are always,
Suppose, instead of 4,000, if you are agreeable to 6,000, which is the current rate,
we can always put to our.
that this additional amount will be create a corpus to the government entity to whom we can give the project. And let that government entity commence at least the projects with that additional, some financial, facility which will become available. For that you will contribute and under court monitoring that can be then utilized.
So first of all, we can have, sorry.
Meanwhile, you can also found out that ED can help you in that. If there are some assets of the builder,
Yes.
we can attach
Yes.
and get it auctioned through court proceeding,
Madam.
that money.
I will assist. We will assist.
Humble submission, my lord, today is that the
Okay,
home buyers
kind of-
have invested their life savings, my lord. The home buyers have invested their life savings. Now, a lot of them are paying rent as well,
Even that money has been siphoned.
my lord.
What will happen?
We
can
are at a,
keep them
we are at
We are at a loss of.
we are on a road, virtually on a road, my lord.
He is in jail, we have already rejected his bail.
We are on a
So what
road,
will
my
happen?
lord. Yes.
Unless the project, how to move the project?
Yes.
Eventually you need that dwelling unit.
Feasibility,
We are
my lord.
grateful. to the
Feasibility.
lordships.
And today, don't forget about the market
Man.
forces and market condition today.
We are
That
conscious.
4,000, 6,000.
It has gone to very high, sir.
It's gone up.
All of you know very well.
We know that, my lord. We know that.
20,000, 40,000, whatever it is.
My lord. My
So
lord, there are
lots-
certain solutions proposed by the NBCC also in a techno-economic feasibility report, which is also on record. And the learned amicus may have considered.
Lord Learned Amicus has given this report today. We will also go through it and will make our submission.
Notice, Learned Amicus will submit a report. Then say, these matters pertain to, these petitions at the instance of the home buyers seek a direction to respond number 7 in bracket Messrs. Mahira Infra Private Limited, as well as to the authorities of State of Haryana to complete the housing project under the affordable housing policy of State of Haryana. The Mahira Homes Sector 68 project comprising how many total units, Mr. Jain?
5,292, sir.
5,292 residential units.
All the 5 projects, 42 towers.
All projects.
Sector 68 has 1497.
In 5 projects, sir, comprising 5 towers.
42 residential towers.
42
Lord, if I can take just 1 second, Lord, in between. Lord, what we had said was, out of the 5 projects, 2 we are in a position to complete. 3, whatever money has been received by us, we will return it with appropriate rate of interest fixed by this Hon'ble Court.
Who is going to accept? At that time, 4,000 was available. Today, why don't you buy apartments for them at the place of their choice?
Because, Lord, the payments made. Lord, the payments made in the 3 projects.
Price or the market
I bow down,
rate
Lord.
has gone to 40,000.
Now, Lord,
they will gain out of interest.
Lord, the payment made is only 10 to 15% of this 4,000. The total payment made is, Lord, 10 to 15% in the 3 projects. In the 2 projects where 70–80% payments have been received, we have given our proposal to complete these projects.
Were to commence in the year 2017-18, and the builder was obligated to complete and hand over possession by the end of year 2021. It is also undeniable that while 2 projects are, your last time report said that 2 projects are.
2 projects, one in 60 sector 68 and
103.
103. In sector 68, the completion is of a level of about 75%. In 103, it is less, but the builder has offered to complete these 2.
Those 2 projects we have offered to complete, Lord. Infusing our money and just recovering the balance.
Number?
Sector 68 and sector 103.
In sector 68 and sector 103, Gurgaon, have been completed up to 75%.
68 has been completed up to 75%. 103 is up to 15%.
Respectively. The petitioner dash home buyers have alleged that entire amount of allotment price has been taken from them, and the respondent builder has siphoned the same somewhere else, leaving the projects incomplete.
Lord, that position we dispute, we have not siphoned off.
At this stage, the issue with which we are concerned is to explore the modalities for completion of the pending projects. The home buyers have suggested that the Government of India entity, namely MBCC, may be requested to take over the projects, take over and complete the projects. Their learned senior counsel are agreeable for a fair enhancement in the allotment price so that the corpus can be created for roping in the new project for an entity like MBCC or any other builder cum developer who might be inclined to complete the pending projects under the supervision of a committee that may be constituted by the court. We therefore request Mr. Rajiv General to contact MBCC or any other government entity, preferably government entity, who are willing to complete the pending projects. Let the terms and conditions on which the proposal is acceptable to them may also be ascertained, so that home buyers can also be made to agree to such terms and conditions. Land makers may also look into the material on record, including the reports said to have been submitted by the Enforcement Directorate, to find out unencumbered assets of the builder in default, The appropriate direction in that regard shall be issued after a report is submitted by the land makers. Post this matter, meanwhile, the counsel for the home buyers will also have instructions. Post these matters for further consideration and so on so date.
But just put kindly consider. The state government also has a significant responsibility because it was their scheme under which the allottees had applied. And the state government also has the resources to a certain extent. They also have a public sector undertaking. If your lordships permit, we could direct the state government also to inquire into that.
We just forgot to mention that since the affordable housing policy has been evolved by the government of Haryana, state of Haryana, and the rate of allotment and beside and such scheme is implemented under the supervision of the state authority. We direct the state of Haryana also to explore as to whether the pending project can be completed by state agencies like the Housing Board Haryana or Haryana Shahri Vikas Pradhikaran HSVP. Unfortunately, no one has entered appear on behalf of the state. Today, we register directly to inform the standing council, who shall have instructions and remain present in court.
Also, kindly consider any such alternate developer would come in only once he knows how much inventory is available for him to sell and how much construction he has to do. So a claim verification process would be required, which can be undertaken by the DTCP of the state government. That is required because the builder may have cancelled several allotments while the allottees would be challenging that cancellation on different grounds. Or the builder may have sold off some inventories which are not there in the records. So one would need to know the amount of inventories available and to which the allottees claims are there and which have been sold or unsold.
The DTC, this district town and country planner, do they maintain any record regarding that?
Madam, they have the
They have the powers because they have issued the license, and the license is under certain conditions to whom the builder can allot and what inventory the builder can sell. Consequently, the state government can seek that information from the builder and also then ascertain from the allottees whether that information is correct or not. For instance, your lordships, in some cases, I learned that the builder has cancelled the allotment on the ground that the allottees have not paid the due installments. Now, the installments were due on a time-linked plan as per the affordable housing scheme. However, the allottees say that since there was no construction going on, how could they pay? So they say that we were willing to pay so long as there is construction. The forensic report says that money was withdrawn from the escrow account without due certification of the auditor and engineer, even from that 70% amount which is to be utilized for construction. So consequently, the allottees feel shortchanged that they paid the money, but that much amount of construction was not there and their allotments were cancelled for no fault of theirs.
There were
There are
also
two
questions
schemes.
on
If I can,
allotment
Lord, I
itself,
can
my lord. If
put
I may, my lord.
my perspective. Lord, the payments are the construction linked or time linked. If, and in every license, my lord, the DTCP while granting license decides whether it is time linked or it is construction linked. Once it is time linked, it was the obligation of the home buyer to pay it.
All these misdeeds are committed by builders only in collusion and connivance with the DTCP and all these authorities. Everybody knows that it's all collusion and connivance.
Those issues need to be decided by an authority established in law.
We can direct the town planner to remain present in court.
My lord.
And then probably you can apprise him.
My lord. They have the powers under Rule 19 to do that suo motu as well, my lords.
So, deem it appropriate to direct the district town and country planner, Gurugram, to prepare an inventory with respect to all the allotments and submit a comprehensive report regarding the
Inventories available.
inventories available.
Unsold inventory.
Lord, the allotment made, the payment received as per the record, Lord, because my instructions are many of them have not paid even the initial allotment money, the 10%. So even that record need to be summoned, Lord, in all fairness. That's
My lord, in that case, there'll be unsold inventories. Those inventories will be opened up. They may be utilized by a future builder.
To summon the builder's report and submit a report to the state. उसमें आपकी verification of the builder's report. Prepare inventory after summoning the builder's records and submit a report to the state. Post on so on. Then we have to grant 2 weeks time to the.
We'll do that, sir. The other excise need not wait for this claim verification.
Grateful, my lord. My lords are also issuing notice in item 8, my lord,
Then
because that's a fresh one.
start
I'm
with
grateful.
that.
Very grateful.
For 9, I appear for respond number 5.
May it please, Your Lordships. Was the High Court, with respect, got completely sidetracked by prayer 4 of the writ petition. Prayers 1, 2, and 3, which are the crucial prayers, which is that whether a title of community forest rights once vested by the district level committee and which becomes final under section 6, subsection 6 of the Forest Rights Act, whether the district level committee on the behest of a project proponent can unilaterally cancel the title. That was, please just see the prayers in the petition for a moment, Lords. If my Lord sees the petition and the prayers, Your Lordship will find at page 284. Petition begins at 253. Please come to page 284, my Lords. A PDF would be 323, I think, if I'm not wrong. Oh, Your Lordships have the physical file. My Lords have 284 minutes. Prayer A, prayer 1, in view of the facts and circumstances, set aside the order dated 8/1/2016 issued by respondent 4. This is the order cancelling the title to community forest rights unilaterally behind our backs without compliance with natural justice. 2, hold that the rights granted.
286. Sorry, 285.
Hold, I'm so sorry.
Hold the rights granted.
Hold that the rights granted under the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act cannot be cancelled or revoked. Any other relief, that relief would be consequential on 1 and 2, which can be relief, maybe compensation, maybe a relocation of the rights, because under section 41 and 42 of the Right to Fair Compensation Act, these rights can even be relocated. They can be compensated in many different forms. Now prayer 4 is what is the High Court has gone only on this, that now there's a stage 2 clearance. How can we now look at it, etc., etc. I've got a lot to say on that, but
Mr. Singh, we will follow what you are saying.
yeah. Now I want to show you a lot of the grave errors, even with regard to
Single judge does not ignore the rights. Single judge says that the rights have to be because the projects have proceeded from phase 1 to phase 2. The best way is to monetize the rights into a monetary compensation.
But the single judge says, right, community forest rights, if any. But my challenge,
that we understand.
no, I'm sorry. This he does not decide my primary challenge. Just see the order for a moment. Just see how the rights get vested. I just want 2 documents your lordship may kindly see.
Rights
Please.
were actually vested by 2013 order.
Order. Please see that order for a moment.
Say 2013 order was void because of not following a particular procedure. They recall the order in
That power is not there. That
Correct.
so
that
please.
issue was challenged before you, challenged by the writ petitioners, and there is no clear finding of the single judge of the division bench that you do not have community forest.
In fact, it amounts to a rejection of my claim completely.
Finding is, how do we work out if you have a community forest?
And the finding is that I have no locus. This is something amazing. No, I'm not something amazing that the Gram Sabha members.
Those are sideshows. We ignore that.
Just
2022 rate.
No, just see the provision. No, just see the title for a moment. Please see P11. I'm sorry, Miss. Sorry? No, Dinesh Kumar Soni.
Yes.
Your lordships are referring to.
It's a similar matter which you.
No, that's an allotment issue, allotment of the coal block. This Kumar issue is allotment of the coal block.
In fact, that is wrong. Those first two matters have nothing to do with this. Well, we are not challenging the allocation of coal block.
No,
and we
this
can't.
concerns both. Taking away the land, encroachment and allotting coal allocation in that very area. Both are challenged in this petition.
No, but Dinesh Kumar Soni is
Allotment
challenging
challenged here.
that is a different coal
Allotment
block.
is not challenged here.
No, in fact, that is a different coal block altogether. Parsa, which is under challenge. We are not in Parsa. We are in PEKB, that is Parsa East Ketan Basin. Basin. Parsa East Kanta
Block.
Kanta Basin.
PEKB.
Yes, PEKB. It's a different block. Now let's just see the title for a moment at P11, Lord, at page 213. And your lordship will see the English translation at 214. This is how the title certificate gets issued. Page 214. Now, this is after the Gram Sabha has approved it, and then it goes to the district level committee. This is the title certificate, title to community forest rights at 214 in English. Now, name of holder of community forest rights, Ghatpara Gram Sabha. Then below that, your lordship see nature of community rights. 31B, community rights in the form of Nistar, right to firewood. 31C, right of ownership, access to collect, use and dispose of minor forest produce. 31D, right of use for grazing. Then there are certain conditions. Now come overleaf 215. Names of the holders of community forest rights, all citizens of Ghatpara Gram Sabha. And then it's signed, we the undersigned hereby for and on behalf of Government of Chhattisgarh affix our signatures to confirm the forest rights as mentioned in the title above mentioned holders of community forest rights, Divisional Forest Officer, Assistant Commissioner Tribal Development and Collector Sarguja. This is a statutory committee, which is a quasi-judicial committee under Section 6. Their order under 6.6 is final. By statute, it's final. It can't be questioned. Now, the project proponent goes to them and says that I had a clearance for forest. I had a stage 1 clearance prior to this. How did you give this? So they write a letter, my lords, to them at page 241, written by the project proponent, not to anybody else. And at 245, my lords, the district level committee issued this order. Just at the behest of project proponent, no notice to the Gram Sabha, no compliance with any law, nothing.
But please see page
Now-
190.
Just
They
a minute.
applied in 2013.
I'm
That
sorry.
you should point out.
I'm sorry. After this
190.
after the community forest rights are certificate is granted, there is no review of it. There's no power under the law to review it. And your lordships have held repeatedly that where a quasi-judicial authority passes any orders, where unless the statute expressly provides the power of review, right or wrong, the order can't be, it has to go to the higher level. They could have filed a writ petition or anything, but they could not have gone behind our backs and gone to them and said, withdraw your order. And he could not have withdrawn the order in this manner. This is the prayers 1, 2, and 3 were pertaining to this. Now the High Court says you have no locus. On what basis that the Forest Right Committee, we had the Gram Sabha had authorized the President of Forest Right Committee because we wanted them to be petitioner number 1, along with the Hasdeo Arand Samiti, which is petitioner before your lordship. So they backed out finally, and that President of the Forest Right Committee said, I don't want to prosecute this petition. So in addition to the first petitioner before your lordship, 6 of the Gram Sabha members, with the authorization of 400 Gram Sabha members, applied to the High Court for impleadment. They were impleaded as petitioners number 2 by 1 till 2 by 6. Out of those, I have myself verified, my lords, the list, the original 437 applicants for community forest rights. 2 by 1 and 2 by 6 are themselves applicants who've signed the original letter, which is at page page 184. The others are all the son or wife of the original applicant, and because a person may have passed away or something, or they were younger at that time. All 6 are members of the adult members of the Gram Sabha, in favor of whom the community title is given. So this is a complete abdication with respect on the first aspect. There are several judgments, lords, where the High Courts have taken the view in respect of this that there's no power of review. I have those orders with me, Lord, I can place those. In fact, Lord, interestingly, the learned single judge...
We need to examine whether there is a subsisting community forest right or not. We are not inclined to injunct the mining operations, but they are subject, if there is an underlying forest right available to the petitioners, to a monetary complaint. Now the courts have glossed over this by saying there is no subsisting forest right indicated in paragraph 17 of the impugned order. Legality and correctness of that finding we need.
All right, Lord, individual rights have already been given to them. We have already paid compensation. They have gone. That's the reason they have withdrawn also. There is no community right which was there. Please see their application.
So
that is important.
We need to examine that.
No, I have no issue. I have no issue. I'm only
because rightly, wrongly, there was a confirmation.
I have no issues.
Community forest rights.
I have no issues about that. Only one thing I'm pointing out.
My learned friend appears for Rajasthan Vidyut Nigam.
Not only one thing
Now,
I'm allotted the coal block, Rajasthan.
Yeah, but don't be unfair to tribals. You don't take away the rights of tribals.
Lord, please have a look at page 190.
Allocation for mining purposes is concerned, that issue stand closed in 2011-12. That we will not permit you to arrange it. But
no,
if you have the community rights or the forest rights, so what is the modality of paying compensation?
No, it's not just compensation. I'm sorry.
This order in the address of coal block. Please,
Mr. Nadkarni, please. But let me just answer. When a question falls from the court, my learned friend should not try to drown it out. I don't think that's fair. This is not how we argue matters in the Supreme Court. Let me just answer. What are you handing across? Let me answer. When a question falls from the court, I think in fairness, my learned friend should not try to drown it out. Look, so far as the community forest right is concerned, just hand me that map. Now, I'll show your lordships, the community forest right itself is not firstly entirely in the coal block. Part of it is outside the coal block, but it's been wiped out by one stroke of the pen by the district level committee on the project proponent's letter. Now, secondly, outside of the coal block, there are still contiguous forests. They, under section 41 and 42 of the Right to Fair Compensation Act, even these forest rights are recognized, and there are different modalities for working them out, including shifting the rights of the tribals. And now just see that map, just show the map. If your lordship just sees the map, they are separate pages. Give copies to the other
Please
side.
have a look at this
Now,
order which I've
just,
given.
now, if your lordship just sees the map, which is,
Lord, please see the
which
order
is-
which I've given, order.
Lord, just see the map with the
Issues
forest.
and says projects will not be stopped.
One second.
Same community rights issue. Please see this.
I'm not on the
Same.
project.
Please see this.
I'm not on the project. I'm sorry. Yes, just see this, the one titled map showing forest compartment boundaries. My lords have that.
Same coal block, Lord.
Your lordship find that much?
Disposed of.
Now please see.
Disposed of.
Now,
No, Mangalsai is not disposed of.
Mr. Natkani,
Leave
please,
granted.
I don't
Leave
understand this.
granted.
Are you so
Not
anxious?
disposed of.
Are you so anxious to defeat the
my
tribal
lord
rights?
asked me a question, I'm answering.
You're a state government entity of Rajasthan.
Mr. Singh, my lord asked me a question, I'm answering.
No, you did not. You interrupted me. Now, would your lordship please see this map? My lord may just kindly grant me a moment. Please just see.
What you
Mangalsai is pending, Lord. Mangalsai,
Mangalsai
Parsa.
Parsa.
That's right. Which is both together. This is Parsa, this is the other one. Same area.
small group, sir.
Now, lords.
And in that matter, your lordships clarified, project will not be affected.
I'm not on the project. No, please just, would your lordship see the map titled map showing forest compartment boundaries? Please take that for a moment, lords. Do your lordships have that, lords?
Got it.
Yes. Now, just see the green portion which has CFR title. The green portion. Yeah, 3 maps are there.
No,
Yeah.
not been given.
The one showing forest compartment boundaries, there's a green portion which is on the right. It says CFR title with an arrow. Now that CFR title which is given,
An intersection which falls within the area you are.
there's a P2002 comes outside of the coal mining block. So it is not as if they could have wiped out our rights completely. Our CFR rights have to be, our community forest rights have to be preserved and protected. So what we are saying, lords, as far as prayers 1, 2, and 3 of the writ petition are concerned, the High Court has abdicated its duty. It has not decided those prayers at all. So far as prayer 4 is concerned, it's a matter of your lordship are dealing with that in another petition. There's some petition filed by another person. Your lordship already seized of that. I'm not on that. But I'm only saying, please don't foreclose me today. Issue notice to them. Let them file the reply.
Please
But my
issue
right.
the order.
My
Kindly
right.
issue the order.
We are issuing notice, Mr. Singh, but only on the issue of determination of the forest rights and the modalities to enforce that right.
For enforcement of those rights.
Modalities, what will be the modality?
Modalities for enforcement. Yes.
Lord, in that
My
matter, your
lord,
lordship just said it will not be
sorry.
affecting
May
the
I
project.
request your
The
lordship,
lordships have
your lordship may
clarified.
say that prayers 1, 2, and 3 of the petition especially.
Issue notice,
Or,
SLP, we'll consider.
my lord.
issue notice returnable to so and so date, to determine 1I, whether there exist community forest rights. 2I, whether there exist individual forest rights. 3I, if so, what is the modality, whether adequate compensation for other.
Or any other remedy.
Any other.
The land or.
41 and 42.
Of area.
You are saying compensation or any
Any
other
other
remedial.
Yes.
Measures, my lord.
Measures.
Other remedial measures have been taken to protect and enforce such rights.
Correct.
To protect and enforce such rights. Then say, it is how clarified that tendency of these proceedings shall cause no impediment on the ongoing mining activity.
Mining, since 2013, Lord.
Ongoing mining activity.
Obliged, grateful to your lord.
Lordship, with regard to respondent number 5, we can accept notice and waive the service.
Five, Lord, we are appealing.
Lord, service may be waived by the respondent.
Five,
R5, you are.
Rajasthan Raj Vidyut.
Rajasthan Raj Vidyut.
Anyone for state of Chhattisgarh also? Because now main issue will be state versus them. States will have
But
to.
standing council can be notified.
Can serve justice.
They can serve standing council.
To serve the
A
respondent.
short returnable date may be considered.
We'll give
Right.
it.
Please, my lords.
You, Mr. Goswami, you submit this issue before that committee. Now we have notified, and that committee will examine this also.
Grateful, my lord, grateful.
This court has wide open so constituted a high-powered inquiry committee. That the issues raised in the incident of petition be also placed before the said committee for examination.
Yes, sir.
Disposed of.
Please, my lord.
Sadhu, what can we do now?
My lord, I know very well, my lord, there is very difficulties, but what's happened, your lord?
You disposed of your petition, directing that these issues will also be examined by that committee.
My lord, that's right. But permit us the affected journalists and concerned media organizations, if they choose so, to place their victim-specific material directly before the HPEC, my lord.
You place the entire material there before the committee, the petitioner or the affected persons.
And my lord, kindly
entitled to place the entire material before the high-powered inquiry committee. We request the committee to consider and make necessary recommendations, stroke report at the earliest.
My request is, my lord, kindly take this petition with 969 of 2026, my lord.
We have directed, that's why once the report will come, then we will issue a certain direction. और इसको उसके साथ ही रख dispose of to the High Court, we are making some observations.
Your lordship kindly made an observation, I will apply, because your lordship, I have applied several times, but matter.
Petitioner, former the petition may, if so advised, move an appropriate application for the High Court, making out a case for out of turn hearing. That such a prayer be considered by the High Court sympathetically.
Highly.
Session 11.
Item 12.
My lord, this is a section application, 11 application. Notice, grateful, my lord.
This may have to be considered, I think. So, why can't we go to High Court?
My lord, deeply disturbing amendments have been carried out in the 2014 Mizo marriage, divorce and inheritance laws of Mizoram. My lord, it's a tribal state.
We appreciate that probably if when the amendment is quite on prima facie, at least it looks easy. But why have you not gone to High Court, please?
My lord, our difficulty is this. My lord, I asked the same question to the petitioner. My lord, it's a very small state. My lord, 11 persons per kilometer is the population density. My lord, the petitioner seems to be extremely sensitive towards the institutions of Mizoram. My lord, be it the legislature, be it the High Court. My lord, she is a working principal there. My lord, she runs a chain business where...
Court is not in Mizoram.
No, my lord, we have an Aizawl bench. My lord, we have an Aizawl bench
We'll
there.
ask the principal bench of Guwahati.
Yes, my lord. My lord, the difficulty is...
What is the purpose of establishing High Court? Why Constitution said that there shall be a High Court for every state?
I bow down, my lord.
This aggrieved lady is not required to come to Delhi. Her grievance could be effectively addressed in Guwahati itself. That is the purpose. Why she should, poor lady, spend on litigation for travel expenses, stay expenses in Delhi?
My lord.
She is entitled to. She has
Yes,
a
my lord.
grievance.
Yes, my lord.
We appreciate that.
Yes, my lord.
We will request the High Court to immediately take cognizance and decide in Guwahati. Don't go to Aizawl bench.
My lord, I bow down. My lord, I asked her about Guwahati also. My lord, she says since the 7 sister states are interconnected. My lord, she has 2 young children. My lord, she lives in a tribal area somewhere near Aizawl. My lord, she runs a school also. My lord, apart from a school, she has a business which has around 1.7 lakh females from Mizoram associated with her business. My lord, the difficult... Just stand there.
In a petition, the High Court will request the High Court to provide you expeditious hearing. Don't burden this woman with so much litigation expenses that she is required to travel to Delhi for fighting this cause. He has a good cause. He must fight and let the High Court take a cognizance of it.
My lords may give me one liberty. My lords, if there's a security issue for her even in Guwahati, then my lords, that would be, because my lords, she is extremely apprehensive with regard to filing in.
Apprehensive of what?
My lord, apprehensive of a backlash back there in Mizoram.
In backlash will be more in Delhi. It will come in the.
Very well, my lords, I leave it at that. My lords, I leave it at that. I leave it at that.
With the benefit of one High Court
Yes, my lord.
judgment also.
Yes, my lord, I bow down, my lords. I bow down.
The amendment in the Mizo Marriage, Divorce and Inheritance of Property Act 2014 which has been carried out by the Mizoram Legislative Assembly. In our considered opinion, there is no necessity for the petitioner to approach this court directly, as a grievance can be effectively redressed by the jurisdictional high courts, by the jurisdictional high court. The petitioner's apprehension that the matter may not be heard at Aizawl bench in a charged atmosphere can also be effectively addressed by requesting Honorable Chief Justice of the Guwahati High Court to list the matter before principal bench at Guwahati, before his own bench, before his principal bench at Guwahati. Therefore, next paragraph further. The issue raised on behalf of the petitioner prima facie requires preferential attention. However, we do not express any opinion on merits at this stage. The instant petitioner disposed of with liberty to the petitioner to approach the principal bench of the Guwahati High Court, where her petition may be entertained in light of the observation made herein above.
Heard by the Guwahati bench. by the
We have
government.
already said.
Very well, my lord. Separate. Grateful.
Dispose. Yes, item 14.
Yes.
Your Lordship, it's a Your Lordship, I was just requesting them blasting activity is still going on, Your Lordship.
Let us get the respondents.
You are coming in. Who is sponsoring the petition first of all?
Oblige, Your Lordship.
September 26, tag with civil appeal number 8176.
What is this?
And court has dismissed it, saying that you have to go to the.
Yes, please.
My lords, the arguing counsel was supposed to join us through VC.
Is there.
Yes, Mr. Gyalshekar.
May I please, Your Lordship?
Please.
May I please, Your Lordship?
Yes, Mr. John.
Lord, I am Gnanasekaran, Lord. I am the petitioner, Lord, in the appeal as well as Lord, the petitioner, Lord, in the writ petition filed before the Honorable High Court, Madras. Lord, I have filed, Lord, the writ petition after making, Lord, representations on 20th of March and, Lord, 11th of June to the High Power Committee, disqualifying, Lord, a candidate, fourth respondent, on the ground, Lord, that she has violated the code of conduct by bringing in political influence. She belongs to a political party, namely Vidudhai Sirthigal Katchi in Tamil Nadu. She was sponsored by the political party. Complaint was given, Lord, to the High Power Committee.
Mr. Ganashekar, we have already constituted election tribunals. You file your election petition and challenge the election there. Where the question of entertaining a writ petition?
At the time, Lord, when I approached the writ petition, the election was not conducted. My complaint was before the committee. Committee did not take any action. Therefore, Lord, I moved the High Court.
Because election has been held. After the election is held, rightly or wrongly, only the election petition is maintainable. And for entertaining the election petition, we have already constituted election tribunals. So you approach the election tribunal, file an election petition there.
Yes, sir. Grateful.
The petitioner is agreed by the election of respondent 4 to the Tamil Nadu State Bar Council. Since the election has already been held and result declared, liberty is granted to the petition to file an election petition before the election tribunals constituted by this court, by the order dated so passed in so. It is later that we have not expressed anything on this.
Because this is again one of those 79, 80-year-old people.
Similar matter.
Similar matter in Pan. I may be permitted to serve through the council, standing council, Millers. And I may be permitted to serve through the standing council.
Yes.
And Millers, then the amount be deposited before this honorable court with the rate of 12%.
Number 2 and 3 are directed to bring the entire amount payable to the petition by way of a demand draft. Entire amount along with interest by way of a demand draft.
Deeply obliged, Millers.
Item 17.
This is the Jharkhand matter.
Lord, the students are protesting for last more than 1 month. The state government firstly, Lord, they cancel
There are multiple examinations.
multiple exams, the 2 examinations, Lord, mainly. One is Public Service Commission exam of the state, another is Staff Selection Commission exam. And now we want, Lord, one either.
Out of anxiety. The judicial services exam is also conducted by the Public Service Commission or by the High Court separately?
No, by the Public Service Commission only.
We are more worried about that exam. What kind of?
So our prayer is either a CBI inquiry into the matter or an inquiry by a former judge of this honorable court.
The former judge, how can a former judge, because these are not inquiries, these are investigations basically. You have to summon record, you have to examine, sometimes you need a forensic report, sometimes you need.
My lord.
All these things can be done by.
That's why, Lord, the CBI inquiry, the students are protesting for last, Lord.
The state.
High Court has a state. The state, one day, it was the same day, it was prepared, it was filed, it was mentioned, it was state. And the state also indirectly supported this.
Lordships, for state lordships, I'll receive the notice. Lordships. For the state, respond number 4.
Are you accepting notice?
Lordships.
For Jharkhand state?
For lordships. Respond number 4, lordships.
R4. Accept notice on behalf of state of Jharkhand. Respond number 4. You have instruction, the matter.
Lordships, I've been told to. Lordships, I was.
Give a show date.
Somebody else will appear for JPSC.
Lordships.
Will have to go.
Yes.
Published.
Which PC is not telling me.
Lordship, I am appearing in item number 18. A similar matter was recently decided. I am requesting for the same order.
We pass that order.
I am great.
Wait, please.
Item 19.
And for the caveat, my lord.
Act has been held to be unconstitutional on the ground that it violates 300A. The learned single judge may not consider it on the question of legislative competence, violation. Sorry.
Protection. Consider. We have to.
My lord, I'll take notice, my lord.
That's right, my lord. Therefore, it was considered.
Either you go
both on
9th
the-
schedule route, MMDR was put in the 9th schedule.
MMDR is put in the 9th schedule.
So, look at MMDR is a mirror legislation to the legislation in 21 for minor minerals, what relates to major minerals. Now you put it in 9th schedule for MMDR. How can you 21 Kerala law be beyond 9th schedule without compensation.
There are two aspects, my lord, which were considered, or which was urged. One was, my lord, when it comes to 300A, there must be a public purpose, my lord, which is underlying the legislation in question. The second is regarding compensation. My lord, the one judgment which has gone into both these aspects in some great detail is KT Plantations. And KT Plantations, my lord, I have placed a judgment on record as well. My lord, if your lordship, what has happened in this case is this. No, my lord, the state was in three parts earlier. Travancore, Cochin, and the Malabar area. Insofar as Travancore and Cochin are concerned, my lord, Travancore and Cochin parts are concerned, there were proclamations, my lord, which were pre-constitutional, the legislations in question. It provided, my lord, for levy of royalty on subsoil mineral rights to be levied by the state, and it has been going on also. What happened, my lord, is that in a judgment called Thresiama Jacob, the full bench of the Kerala High Court, my lord, rejected a challenge on the ground that even for private property, royalty cannot be levied, even if, but the challenge was on the ground that in private property, the mineral rights also would vest in the private person, and therefore royalty cannot be levied. Full bench held otherwise. Said that in so far as subsoil mineral rights and subsoil mineral rights, minor minerals are concerned, the other one is governed by MMDR. The state would still be entitled to levy royalty as such under the minor mineral concession rules, which are framed under section 15 of the MMDR. No, my lord, the matter was taken up before this Honorable Court. This Honorable Court held that these are either zamindari rights or Janmam rights or whatever the manner in which it is called. My lord, there is a detailed discussion of the land tenure. But ultimately, it was held that there is a statutory vacuum insofar as the Malabar area is concerned, part of the erstwhile Madras presidency, and therefore, my lord, they are insofar as private properties are concerned, royalty cannot be levied on the subsoil mineral rights because there is no vesting of the subsoil mineral rights, my lord, in the state, insofar as private properties are concerned. This, my lord, Malabar area, this led to a situation, and this has been found as a fact by the learned single judge also, that there was complete lawlessness. In the sense, my lord, that they did not pay any royalty, my lord, insofar as the permissions are concerned under the MMDR and the state rules are concerned under the MMDR, framed under the MMDR, that no environmental clearance was necessary, nothing was necessary. Therefore, there was complete lawlessness as such. Now, my lord, what we did, the legislative response, what we could do was to bring the Malabar area on a par with the law that was prevailing, my lord, under proclamations, pre-constitutional proclamations, insofar as the Travancore and the Cochin area are concerned. Therefore, my lord, the act in question, the very short legislation said that the subsoil mineral rights would vest in the state, even insofar as private properties are concerned. Challenge was mounted on the ground of legislative competence inter alia, and, my lord, then violation of 300A as well. Learned single judge went into it in some great detail and upheld the legislation, and, my lord, set it aside only in relation to some demand for royalty which was made prior to 2019, which is the date on which the act is enforced. Though, my lord, it is passed in 21, there was an ordinance from 2019, and therefore from the date of the promulgation of the ordinance, my lord, the act is given force as such. Division bench, my lord, upholds the judgment of the learned single judge insofar as legislative competence is concerned, and said that it could either be 18 or 23 of list 2 or 43 of list 3. But when it came to the question of 300A, no, my lord, what we had contended was that please get into the substance, my lord, of the manner in which a 300A challenge is considered, my lord, insofar as acquisition of property is concerned, into the KT plantations is concerned. My lord, it goes into a great detail. Now, if your lordships kindly come to paragraph.
Mr. Giri, at best you can argue that this is only a declaratory law of something which had already vested by way of eminent domain of the state. But that was never the argument for the state. The argument for the state was a statutory instrument to occupy a legislative void indicated in Now, if that Prasamma John holds, then the argument of eminent domain does not lie. That this is a declaratory law of something which was already owned by the state.
Prasamma Jacob, my lord, does not go against eminent domain.
No.
It doesn't go against eminent domain.
That the right, the subsoil rights have to vest in the state by operation of law.
This is the law.
Since the operation of law is a legislative vacuum in the Malabar area, whereas covered in respect of other portions of the state of Kerala, you cannot claim ownership just because you are taking royalty. In terms of the
We did not say it that way. We said, please look at the Act. The Act contemplates a vesting. And suppose, my lord, it is competent for the legislature to declare that the subsoil mineral rights vest.
No doubt of legislative competence. It's a question of constitutional virus under
infirmity insofar as
under
300 A is concerned.
19
That's right.
of Constitution.
That's
where
correct. That's
the
correct.
State vests certain properties which were not its properties because of Prasamma John saying that these were properties of the Rayatvars of the area. It must have a just and reasonable compensation.
My lord, it is on that. It is on that, my lord, that the twin provisions regarding.
Exceptionable logic.
Lord, I'll take your lordships to that. Lord, it requires.
Says there is
Lord, there is.
either you reenact and seek 9th schedule reservation.
Now, my lord, the problem, there is another problem which is crept about on account of, but that I'll take your lordships to that later. No, my lord, what has happened?
KT is noted, either nil or no complaint.
9th schedule reservation, my lord, we will require the assent to the president. But before that, my lord, could your lordships, my lord, there is a huge burden now cast on the state by reason of the direction for refund of royalty. But that is, my lord, I would pray for that only if your lordships are prepared to examine this, my lord. But please have a look at the act in the first instance. Sorry, the 367. But I'll just take about 5 minutes, my lord, on the question of plantation.
Under the Act, you have been collecting royalty now.
Yes, my lord.
The High Court now says to refund it.
Yes.
Problem is, Mr. Giri, that is the whole problem because unfortunately it's not a declaration of any pre-existing right. It's only creation of right first time.
No, my lord, my lord, declaration of a pre-existing right, suppose it is upheld.
Would have understood that argument, but that argument is cut short because of the Supreme Court judgment.
Supreme Court will not destroy the Prasamma Jacob does not get into that. Prasamma Jacob simply says that in the Malabar area there is no law.
Prasamma Jacob predicates this finding that there is no law by saying that in absence of law, the consequence is that the subsoil minor minerals are of the landowner until and unless such land is held by a pattadar under the Estate Acquisition Act.
But that's only in relation, my lord, to the area where the Travancore and the Cochin proclamations were not valid.
Yes, saying.
And therefore, my lord, we have
public purpose, Mr. Giri, is well taken.
That's right.
The state had a public purpose to make the law.
That's right.
Now the question is that when the state has a public purpose to make a law and thereby vests certain properties, will it not be a part of the legislation to qualify the test of 14 and 19 to have some compensatory package?
That's right. That's right. This is the argument.
And if you have to circumvent this,
not
circumvent the
not circumvent it, my lord.
I mean constitutional compliance.
You have to look into the correct, my lord. You have to look into the statutory scheme. My lord, please have a look at the legislation which has been struck down. It's at page 368 onwards. My lord, it hits us very hard. And therefore, my lord, I would pray for a little time of your lordship's intelligence, my lord, to make your lordships to the
practical dynamics of the
how much they will not be practical dynamics, my lord, for a small state like Kerala. It hits them very hard.
Estimated burden is.
Estimate burden is about 1,000 crores.
2,000.
Estimate burden, I am told, this is my instruction, this is about 1,200 crores. My lord, he estate.
Back it up now.
No, that's my lord, because he must have got updated instructions today morning. And therefore it happened. The direction for no, my lord, what now happens is, it is not as if the royalty is paid on two fronts. No. That argument is also not taken note of by the learned single judge, not upset by the division bench. Would your lordships kindly come to page 368 and 369? That's where he acted. Lord, on this question of compensation, before your lordships get into that in a moment, what really happens now is that land is left intact.
Now, but
if he doesn't win the mineral, then there is no levy of royalty.
do you still have any contemplation for revisiting the legislation?
You can make
We can.
another law where
We
you
can.
can adjust the royalty against compensation.
Yes. That's what, that's precisely what, my lord, that's
We
precisely
cannot
what.
advise you on legislative
No, my lord,
policies.
my lord, I am not trying to take advantage of what fell from your lord.
Not legal.
This is what I have.
Do it.
No, my lord, what happens is this. They should have made it clear. No, my lord, we don't win the minerals. We don't extract it. The state doesn't extract it. What the state does, my lord, is that there is a declaration that the subsoil mineral rights are vested in the state. No, my lord, when does the levy of royalty come? When he wins a mineral. Sorry. What happens is this. Though there is a statutory declaration that the minerals, subsoil mineral rights vest in the state, we don't take it and sell it. The owner of the property, and that's what all of them were carrying on quarrying with gay abandon. They sell it, and when they sell it, beyond all this act contemplates is a levy of royalty on the quantity of mineral which they extract and they sell. Notwithstanding this, therefore, the compensation part comes in. All that it required was one sentence here saying that, therefore, they are entitled to do that. They are actually doing it.
Mr. Giri, it is like, suppose you tell the rubber plant owner that, oh, like the 10% of your product will belong to state. Or you tell your tea estates that 10% of your product will be of state. This is something like the same manner, it probably going by the legal position. The land belong to them, subsoil belong to them, mineral, if any, belong to them. On extraction, you are saying you will charge royalty.
No, not that, my lord. What we have stated is that in two parts of the state, or as it existed then, the subsoil mineral rights, my lord, statutory vesting is in the state. And there is a royalty levied on all minerals, my lord, which are extracted therefrom by the owner and selling it. The MMDR rights, the rules framed under the MMDR for minor minerals by the state comes into play, and there is a levy of royalty in only insofar as the licensing provisions are concerned. What we have done is,
Giri, that is why when you open the case, we told you, MMDR is item 90 of 9th schedule. If you could have got that protection, easily your law survives.
no, my lord, that's what I'm saying. My lord, they only need have done that, but in practice, that is what is happening from 2019 onwards.
You can't give the blessing on 9th schedule to all
Sorry,
The
legislators.
vesting comes only in 2019.
Correct.
So after that,
No, but before that, my lord, it was complete lawlessness. Nobody required a license. Nobody asked for a license. Nobody paid a license fee in this part of the state, which was part of the Madras. My lord,
19 law.
Mr. Datar, let us see that how they come out with a, what kind of amendment they are
Yes,
proposing.
my lord, one more thing is very important. The
I-
judge has just touched upon it.
Sorry,
Which could be
can I
fatal
just,
to the, my
in
friend.
response to what fell from my lord, the Chief Justice. Any other activity in this land is not being protested by the state at all. For example, my lord, one part of it, they want to carry on a rubber plantation, let them do it. Many of them are doing it. What happens, my lord, and if they want to exploit commercially any portion of the property insofar as the minor minerals are concerned, they are permitted to do so. We are not standing in the way, notwithstanding the statutory declaration under this enactment that it vests in the state. Therefore, my lord, that is not being touched.
once it is vested,
All that is,
it's after-
but I agree with what fell from your lordships. Shouldn't we have said that here?
Last, you should have more.
I asked them.
You have sharp legal mind.
Lord, in my own-
in a state and
In my own humble way, Lord, I'll ask them to do that.
For this mining, are they not required to have any environmental clearance, any regulatory?
They were not having it, my lord. That's what the learned single judge said. They were not having it.
My lord, may I just say one thing, my lord, with the lordship's permission?
It is not required. It is required by them, but the learned single judge says that undisputedly, page number 481, para 61.
Deepak Kumar, various judgments of this Hon'ble Court saying that it cannot be conducted without a proper this thing, and the argument is absolutely wrong, madam.
In what argument is wrong? I am saying about the judgment of the learned single judge.
My lord, I wanted to say just one thing, if your lordship permits me.
Yes, Mr. Datar.
Yes, my lord, my friend, learned friend is partly wrong because in the Travancore Cochin law, which he says is different, there is a provision for compensation. In the Malabar law, there is no provision for compensation. Secondly, my lord, my learned friend, if he is going to amend the law, today the law is fatal because of the second proviso to Article 31A, which says that if the lands are within the ceiling limits, you have to provide market compensation, and 31A applies to estate or any rights under that estate also. So that also they will have to take care of. They have to provide for compensation, and those lands which are within ceiling limit will have to be provided market rate. That is the mandate of Article 31A of the Constitution, which has not been taken note of. And in Travancore Cochin, there is provision for compensation. In Malabar, they say no compensation. So serious amendment, maybe the land law has to be redone completely.
I'm sorry, because neither the learned single judge nor the division bench has referred to it in that way, and they said that those two proclamations have a
It
provision.
had to be reenacted, my lord, completely.
Lord, I would
State council will be to.
In which item you will be able to accept notice?
Two SAPs,
So and so accept notice.
29034.
Six of.
And 29039, we are accepting it.
Meanwhile, the royalty amount as directed by the High Court is there. However, the petitioner state will also not levy any royalty. It will also not levy and recover any royalty till further order.
Stay of refund.
Refund stay.
No stay.
Grateful.
But you can't also now recover for some time.
We are only now for you to.
At least one
Let them come back.
saving solution for the state.
Via media will have to be.
Only thing I wanted to point out, if we will have to get this from the government, suppose even if we win, it's a Herculean task.
It's another problem.
And in fact, in case you ought to feel that is appropriate, to direct them to whatever be so far the petitioners are concerned, let them deposit the amount.
It's a state, my lord. Why should?
No, because if it's a.
Why should they be worried about the solvency of the state?
We will see. Do they have money to deposit?
In fact, many people, in fact, due to revenue recovery, people.
You must be aware of that civil suit the Kerala has filed.
The thing is, many people against them, they have started recovery right from, even much before 2019, and revenue recovery was initiated, and people are losing their properties. And of course, this is only with regard to recovery. But what I'm suggesting is, in case, some amount has to be deposited by them in the court, at least we'll get something out of them. Otherwise, it's very, very difficult.
No, we'll take care of that.
Right.
That should be staying the recovery.
Yeah.
Great.
We have skilled recovery, we have also stopped them from levying because now the.
Yes.
Deeply.
Say the refund.
You not a direction.
The other one, yes, of course.
Sir, you will not also recover it for us.
Of course. I don't think they'll be that foolish. But anyway, now that your lordships have passed an order.
One thing, your lordship may indicate that in the event, ultimately refund is made, reasonable interest will have to be provided. If they are going to retain the money now, some reasonable interest has to be provided. Whatever your lordship is, 6%, 7%, whatever.
Mr. Datta, they will take out a law where compensation will be adjusted.
They'll pass a validation act, Lord.
Yes.
Deeply obliged.
Great.
Because I'm requesting for a passover on item.
For validation, I have.
Item 20, my lords, I'm requesting for a passover, my lords. I'm being led by the learned SG.
Passover. No passover today, on some other date then. After first.
Lord, item 21, my.
31st.
Item number 20.
In item 20, my lord.
And like the only argument is this, page number 126 is the similar order. I'm only seeking that. That's all, man. Deeply obliged.
Would your lordships then consider having item 20 next week, my lords? There's some urgency, my lords. There's a issue.
It has said first week September.
31st or first?
Deeply good.
22.
Please.
Lordship, may I have it then on 31st?
Which one?
22.
Which one?
Prajwala.
Prajwala, yes.
Yes,
32.
Your Lordship may,
There is another matter.
There is another.
CSAM.
my lord, that is only on child's, my lord, I've gone through that matter.
My lord, I'm only, that is on, my lord, your lordship, you should notice, as far as tagging is concerned, my lord, that is only on reporting by the intermediaries. My lord, that is one very small issue of this larger thing. My lord, we are looking at a reporting mechanism to the.
We are not saying anything, we are only saying it will.
No, let it be heard. I'm not one. What happens when the matter is tagged, unfortunately, my lord, then this whole thing gets submerged. This is a larger issue. And my lord, in fact, your lordship.
Will get submerged here.
My lord, I hope sometimes, my lord,
Entire ocean will submerge that small sea.
But my lord, what happened is the lead matter, my lord, it gets a little complicated. Your lord,
This problem that these are so serious issues.
It's extremely.
Consideration, deliberation. And the judicial forum is perhaps not equipped to go into this exercise. There are issues where there is a sense of legislative lethargy, which we need to catalyze. But to take over this responsibility is perhaps biting too much.
My lord, I'm so grateful, my lord. I'm completely, but my lord, we had worked with the government for a significant period of time. And in fact, right. Well, would your lordship consider giving a returnable date? Right.
Returnable
expeditious disposal.
Bail application. Item 23 bail application. Though we are not inclined to entertain this written article.
We may file.
However, keeping the sections of the pursue this case, we request the High Court to take up criminal miscellaneous bail application number 1291 / 2026 and dispose of the same at the earliest.
But the problem is that there are two types of lists in Allahabad High Court. One is the fresh list and the other is the additional cause list. And the number never reached that, my lord.
We just passed an order, considering this is a bail application, this will be taken up at the earliest.
That's what.
For us 24 and 25, I'll request for a password. I'm led by Mr. Sibbal. My lords, I'm in both the matters. My lord, led by Mr. Sibbal. My lord, he's on his leg.
For notice,
my lord, we take it over after lunch. My lord, that's simple.
For notice.
Singly wants a notice.
You will say no password.
No, I didn't say I corrected my learned friend. I corrected my learned.
Just your lordships may see the prayer.
Anyway,
That's
My lord, may have it after lunch.
it's impossible.
Your lordship is
led by Mr.
something,
Sibbal, my lord.
everything he says, no reason, nothing.
Notice on that.
My lords,
Will take up along with, though it is not connected.
No, only one side.
my lords, they are different matters.
There is only one side.
That's why we will keep.
They are, they have stayed the investigation.
Yes, that is why we are giving notice. They are giving notice of that.
A short date it will come.
Even if I put an estimate,
We can today issue notice only, we can't stay the order.
then give a short date, very short.
Yeah.
Short date. Because what has happened is, in the meanwhile, I'm not asking today, but in the meanwhile, I can't investigate.
Listen,
Forget the rest.
Dr. Singh, it runs contrary to our order staying arrest in another case.
Yes, absolutely.
Because there we have said on condition of cooperation.
Absolutely.
I'm very
So
grateful.
we'll look at this.
That matter is also listed today, but there is some letters.
Not to
We
arrest.
thought that at least this old habits dying hard in that state will now stop. But we are sorry to say that whosoever may come, the old habits.
You file a bail is pending, you go to 482, you get what you don't get.
Not 482,
226. Constitution and stay of investigation. All your judgment.
There are several modes of fighting political battles, but not like this.
That's fine. Only an early returnable date.
It's contrary to your lordship's judgment, Mullahs.
It's contrary to many judgments. It's contrary to many judgments.
The impugned order is.
Impugned order is.
We are should notice.
Oh, very well.
Well, kindly give me a fixed date at least, actual date. Please give me a fixed.
Yes,
I'll be very grateful.
27th, of course, the High Court is hearing the matter, Mullahs, on 27th August.
High Court.
On 27th.
Because that
3 days later, the matter is being heard, Mullahs.
in that case, your lordship must allow the investigation.
They will take an adjournment there then, Mullahs.
Either they take an adjournment or your lordship allow the investigation.
This is all, Mullahs.
It's a very fertile area.
Yeah. That's right.
Next time matter will be heard, there will be some another new round of
So give me an actual date, my lord, otherwise this argument will be
Yes, sir, you will.
very bad.
My lord will give. Obliged, my lord.
That's 24 and 25. Yours is 24.
Both 24 and 25.
Both 24 and 25, my lord.
Same petitioner.
Yes.
Again,
Yes.
quash.
24 and 25.
And the other matter, my lord, the next 45, my lord, they have to issue, they have to file a reply.
45 is only reply 5 being filed.
They have not filed, my lord, not filed.
Letter, my lords, in item 50.
You,
45.
you need time?
Yes, my lords, we
And
need,
then state council seeks and granted 2 weeks,
my lords, to be.
2 weeks time to file the counter affidavit, post on so and so date, interim direction to continue.
Interim order to continue. Obliged. my lord.
Much.
Direction to continue.
On 46, the council had joined through VC.
What happened? Somebody is appearing?
He's appearing through VC.
Court master, somebody is appearing in 46, please show.
See the quantities, my lord.
Yes, yes. Yes, Mr. Mehta, argue. Unmute yourself.
Lord, this is prayer for anticipatory bail. My lord, I have been implicated upon the third person's disclosure statement. So, my lord, first they registered an NCB crime number 8 on 15th of February. And on 15th of February itself, they raid my house. Whereas, my lord, the disclosure statement which they have recorded is of Jasbir Singh, who's the third person which stands recorded on 16th. And then my name figures out. When I point this thing to the High Court, Lord, they take a U-turn. They say that no, in fact, the original accused from whom they had recovered the contraband. Lord, in fact, the main accused from whom they recover this contraband, Harpal Singh and Ranjot Singh, they are both let go of. The next day, they say that on 16th, we call them to our office, we get recorded their statement under 67, and then they name Jasbir Singh. On the same day, they say that Jasbir Singh stands arrested. He then names me. Whereas their Panchnama shows, and I have shown the CCTV footage, Lord, on 15, they come to my residence, they ransack my entire residence. Lord, page number 67 to 71, I have the CCTV and the original footages which I have reproduced. Lord, on 15th, now, Lord, my case for anticipatory becomes more stronger because they ransack my house, they do not find anything. Lord, they take away both my vehicles, they arrest my wife, they arrest my brother. My wife gets released when the High Court intervenes. But my brother stands implicated when they say that he therefore harboring me. But Lord, even in my cars, there has been no recovery. Now, Lord, surprisingly, the arbitrariness does not end here. Lord, they visit after every 1 week, torture my family. Lord, they recover nothing. And then, Lord, even during the pendency of the bail petition, Lord, the IO along with local police goes, and on video footage, Lord, he says to the family members and the mother that we will implicate you as well as your son unless and until your lawyer stops arguing before the High Court. Lord, this threat, I brought it on record. Para 19, the High Court judge observes that this is minor heat of the moment. And my lord, eradicated that this should not happen again, but this was minor heat of the moment and words were uttered in the heat of moment. My lord, this actually goes to the core of the case. I am not the main accused, my lord. The main accused from whom recoveries were effectuated have no connection with me. High Court has adjudicated 2 crimes. Now, my lord, I was briefing my lords on NCB crime number 8. But then, my lord, surprisingly, despite raiding my house and saying that I am on run since 15th of February, they say that at my very residence, I met another accused who has been arrested in NCB crime number 14, and I, along with rest of the companions, sat in my residence and we conspired again that on 6th of March there has to be a fresh consignment. And on the basis of this, I now stand implicated in NCB crime number 14. Now, my lord, surprisingly, where the lacuna arises, on 11th, this person is presented before the trial court. The remand paper do not name me. My lord, they present him again on 13th. The remand paper does not name me. Lord, on 16th, surprisingly, I am being named in NCB crime number 14 also. Now they say that while arresting NCB crime number 14 main accused, there were certain calls which have been exchanged with me, disregarding the fact that he's my neighbor. And I have brought land from him, which is a rasta, which is a way, which is a path towards my fields. And I have acknowledged that even before the competent authority. The competent authority evaluates my 10 years bank statement and finds not even a single penny of proceeds of crime. They release my property. They release this person's property as well. Now, my lord, the question which the court has considered is on two aspects. One, that there can be rigors of section 37 which can come into place. And the second one is my lord Samarth Kumar's judgment in which the anticipatory bail was denied. But my lord, I have in my petition also have distinguished that both these conditions will not be met because in my case, my lord, there has been no recovery. I am the person whose house has been raided. I have given my request that I am willing to participate in the investigation, at least allow me to give my evidence. I'm till date ready, my lord. I'm ready to give my passport, my mobile phone, all my electronics have already been in their possession. They have taken away. My lord, what I'm seeking is that I'm only seeking one indulgence from this court, that at least allow me to join investigation. I should be at least heard once by the investigating agency who has been prosecuting me. And my lord, the second limb to it which has been going along is that my mother, my family members, my two small children have been repeatedly approaching the High Court that they have been torturing us. My lord, in this contingency, custodial interrogation is not warranted. The recoveries, whichever they have effectuated, is from person with whom they have not been able to produce any proof whatsoever. Even before the High Court, 31 pages long High Court order, my lord, their reply does not contain a single piece of evidence. My lord, whether corroboratory or substantiative, they have not produced a single evidence. No call details, no, my lord, my interaction with them, no financial transactions with them, my lord, nothing, my lord. And they are the persons who have been initially arrested and recoveries have been effectuated. I am the person who has been named in the third person's disclosure statement.
Well, thank you. No case to grant bail.
Your lordships are examining this question, my lord. We have already vacated. The question is, my lord, where can the compensation, damages or mean profit, whatever name we may give, can be decided by the district collector. My lord, this is the order, my lord, your lordships are examining.
But this has been distinguished, my lord, by the High Court. If I may just point out, I don't want to interrupt.
Yeah, I'll come to that.
And computing except paragraph.
Para 5 and 6 issue notice returnable subject to payment of areas of lease amount, if any, to the respondents within 4 weeks. Computation of damages as directed by the High Court shall remain state. Meanwhile, no coercive steps shall be taken against the officers of petitioner corporation on account of delay in the acquisition process. However, that's not here, not present. Because here that is paid. Now, there is one more order, your lordships. I don't wish to duplicate, but there are 3-4 matters pending from the same state with regard to the same ONGC acquisition.
There are subsequently also there were some matters.
Yes, my lord. One thing I must point out, my lord, it is sought to be, my lord, distinguished. Which this was placed before the High Court. That now the High Court, the Supreme Court is examining. Please do not pass this order. Lord, this is how the High Court is pleased to distinguish. Lord, page 34 of the order, my lord. The submission is at page 33, page 52. I'm not reading, my lord, submission. I'll just read one para, rest I'll not read. Before proceeding to issue any direction, we may note at this juncture the vehement submission of learned senior counsel for the ONGC based on the order of the apex court dated so-and-so. The said SLP was filed against the judgment of so-and-so. The distinction is, my lord, next page, my lord, para 55. Your lordship, my lord. Dealing with the said submission, we may record that the issues being decided by us herein are for the period of illegal occupation of the land in question. Same issue, my lord, you are pending before your lordships. After the notice to quit sent by the landowner lessors served upon the ONGC in a monthly tenancy, which has automatically been determined at the end of month, that is 31st of August 2019. This issue has neither arisen in special CA nor has been determined with a judgment dated so and so. As the issue before us is different and distinct from issue determined under the judgment and order dated so and so, we are afraid to appreciate the argument of the learned senior counsel for ONGC asking us to desist from passing any order for fresh determination of rent, taking into account the annual rent value. Well, therefore, direction, page 57. We therefore direct Collector District Ahmedabad to authorize a competent officer of his office to determine the monthly rent, etc. But this is the question, whether this can be done by a district collector. According to us, there is no statutory power. It has to be done, my lord, by a civil court, which is being examined by your lordships. This distinction is without any difference, my lord, with my respectful submission.
No, my lords, this, after many years, my lords, this was 2006 lease, which was temporarily acquired for 3 years, my lords. Temporary acquisition, never returned back, the acquisition was never completed. Ultimately, in 2019, we requested that please vacate the land.
What happened to acquisition process?
We are not acquiring, my lord. We have retained, we have given the land back to them. We have returned them. We have vacated and returned them. We don't want to acquire.
The question is that occupation between the termination and the day on which you have returned the land.
My lord, there is no termination also. We have been paying the lease rent throughout. They say you quit it or acquire it. We quit, saying that we don't wish to acquire. Now the question is, for the damages according to them which is caused because of our continuance, and who will be the authority who will adjudicate the quantum of damages, collector or the civil court?
According to you, who will adjudicate?
The civil court, my lords. That's my case, my lord, in all these cases. Collector has no jurisdiction.
Rate is maintainable.
Of this order?
No, my lord, no, not taken. My lord, the reason is this, my lord, legal reason. The question as to whether we were in illegal occupation or not will have to be determined because we were under a lease.
Solicitor, that has been determined. Then we have to go into the question preceding the issue that you are raising.
Look, then, my lord,
First thing, see, what is the reasoning of the division bench? The reasoning is, this is not a registered lease reserving an yearly rent. If it was a lease reserving an yearly rent, then there is no question of illegal occupation, market rate, mean profit compensation. It could have been only a termination in terms of section 111 of the
transfer of property.
Yeah. Now, that 111 of the Transfer of Property Act has not taken place because you have been regularly paying the rent. Whether the escalation of rent was as per your discretion or it should have been on consultation, these are not really breaches which would amount to a determination of a lease which has which is not determinable otherwise apart from breach of the terms. So that issue they have decided, saying it's not a registered instrument, so it would be treated to be a lease with a monthly rent.
That is also in challenge before your lordships.
That is what we're saying.
That adjudication is also on challenge.
Decide that question, whether the interpretation of the document.
Yes, whether that
was right or not.
Civil court, how many years it will take in determination?
So already this is the third round.
That can be, my lord, an equitable consideration. I am only on law. And in all matters, my lord, your lordships were persuaded to issue notice and injunct the collector on this ground.
If we dispose of all the matters, subject to both sides agreeing, we can appoint some mediator there, some respectable, some retired district judge or someone can be appointed as mediator to determine.
I can take it.
Collector is also some government bureaucrat. You will make a hue and cry that they don't know how to determine it. say retired district judge can be the mediator to determine.
I can take instruction. So following from your lordship's, my lord, without
That's right, my
applying
lord.
mine, my lord,
I
I
only
think.
please, my lord, so many years have passed, we finally got some relief, my lord, after so many years. And it 2 rounds of litigation before the High Court, then the Supreme Court, undertaking to vacate, undertaking to acquire, not complied with.
You are entitled to certain amounts. The question is only of determination.
That's right.
Going to civil court
I think-
means years and years.
That's right.
Collectors also, they are busy with multiple administrative responsibilities. They don't get time to adjudication this kind of. If some retired district judge,
I bow down.
Mr. Solicitor, you can
Lord,
also
I-
suggest 1 or 2 names, you can also.
Let
suggest.
me take instructions, my lord, or persuade, my lord, ask my clients. But only thing, my lord, High Court is still monitoring the matter, my lords. High Court may not, my lord, now further persist with the matter. And the collector may not start computing.
Instead of going into an adversarial situation, please mediate.
I bow down,
and
my lord, I
come to
bow
an
down.
agreeable solution, because
Yes, sir.
The only point I'm highlighting, after many years, we've got.
we understand,
you
we
know,
understand.
Issue notice, then say, so and so accept notice on behalf of the contesting respondents number 1 to 14, then say during the course of hearing, we have suggested the parties in the instant case as well as the cases which are coming before this court, that the amount of compensation, that the right to seek compensation and the consequential amount of such compensation may be determined.
Compensation is for land acquisition also, where we are acquiring.
May be determined by a mediator who can be a former district judge. Then counsel for the parties seek and are granted time to have instructions and also suggest the names of the retired district judges.
Great.
Post the matter on so and so date. After 2-3 weeks,
My lord, would your lordships, High Court may not, my lord,
means
and
and why further, since we are proposing to refer the matter for mediation, further proceeding before the High Court are stayed.
No, some fixed date may be given because the matter is fixed before the High Court today, my lord. So if you, yes, it was fixed today.
We have asked, because we are sending to mediation, therefore we will talk to High Court.
Some fixed date here, your lordship is making, that's all.
Will.
Will come after 3 weeks.
Yes, so item 48.
Lordship, already 90% demolition has been done.
Why are you coming to us?
To the High Court again.
But Lordship, High Court is not considering these facts.
We have
Further-
already, once we have intervened, that does not mean that on every smaller issue we will come to the.
May kindly grant me interim.
Notice to interfere with the impugned order made out dismissed. Item 26. Yeah, just a minute, your matter is ready.
Item 49.
No, this is,
Just a minute, wait for your rights. Item 49.
This is the one page, Malas.
Notes, note, no.
That is different. 49.
We don't have the note.
They are just submitting it to the court.
Just give me. Malas, may I just please sit, Malas? Malas, there are 3 aspects. First is the energy. So if your lordship will see, Malas, point number 1, energy areas. This is para so-and-so of the note of the learned Attorney General. 13,066 million units mentioned therein does not account for 1.2 lakh units supplied per day to Himachal, and which finds mention at para 6 in minutes of meeting of so-and-so, and next with the Union of India's affidavit dated so-and-so at page so-and-so. It is clearly recorded therein that energy is being supplied from Bhakra-Nangal project to the consumers mentioned therein as mandated by Bhakra-Nangal agreements and decisions taken by BBMB from time to time. Himachal Pradesh is mentioned at serial number 3 thereof. After adjustment of 1.2 lakh units per day, the units due to Himachal stand reduced to 11094, that is 13,066 minus 1972. This, Milids, the judgment says in para 41, you have to adjust what has been given. Now, point 2, Milids, the cost which they have to give to us for the project. Himachal Pradesh liability is assessed at 420.77 crores. That's as per the note. Correct figure is 1611 as on 31/10/11 and 6368 as on 31/3/26. Details of interest paid, etc. set out in affidavit. Now, I'm not pressing this. I'm not pressing this, Milids. I'm just stating it as a fact. Now, this, Milids, the capital, that's why it's in brackets, Milids. The capital cost of 420.77 crores or 4,207 million has been divided by a rate of 385 per unit to arrive at 1093 million unit as per the note. Consequently, 13,066 minus 1093 million units is equal to 11,973 million units asked due to Himachal as per the note of the learned attorney. It is submitted that this conversion should be on the basis of the O&M rate, that is the rate at which all states have been and continue to receive power from BBMB. Average O&M rate from 67 to 2011 for 3 projects was 11 paise. Current O&M rate is 79 paise. Normally, if we divide 4207 million, the figure which the learned attorney mentions, by 79 paise, it comes to 5326. Therefore, based on the current rates, the units due will be 11094 millets minus this. Again, I leave it to your lordship, but this is the rationale. Now, 3, para 21 of the note. The note of the learned attorney general suggests that the units mentioned therein be given over 15 years. However, the affidavit of the Union of India, that was 2013 millets, and the written submissions of the learned attorney general dated 24/8/2020, Mr. Venugopal's millets, in para 13 suggested a period of 30 years for energy disbursement. This period may accordingly be increased, millets, from 15 to 30 years. Now, millet, these are the 3 things. I leave it to your lordship, millets. The first is absolutely fact. The second, wherever your lordship feels, millets, it should fit. And the third, millets, this O&M rate is what we've paid throughout, and they are paying. In the past, millets, since the time the units were being supplied, and even today, millet, that is the rate.
Mr. Attorney, this period of 15 years is consistently.
15 years already passed. Therefore, 15 years, that's why I said.
There's so many compromises made by us. No interest, no nothing. All these years, what have we been paid?
Last but not
Why
least,
should we have waited for 15 years?
Well, Himachal is obviously doing much better than Punjab. Himachal
on,
is represented by my learned friend. They have Punjab has to make
that
do with
seems
me.
to be Punjab.
Obviously, they're doing much better.
I suppose
they can afford him. Punjab has to make do with me.
In all my exchanges with all the officers. That's all I was going to suggest. I had almost more than a year or 2 of interactions with all the officers at the highest level and the ministerial level. So, and of course, this Himachal versus Punjab being financially richer, all that, of course, to discuss at great length. I thought ultimately, if this is the final solution, where a cashless solution, which will probably accommodate a large factor, we have arrived at that. Union of India has no say on that, beyond that. And as I said, BBMB has gone into great at length the calculation to be relevant for the purpose. So I don't think you've got anything more to say beyond my note. Himachal has serious reservations on Punjab's questions.
Well, we will examine this one.
My lords.
In fact, my note captures all the. Yes.
Well, he's gone through, I think, 15 rounds of negotiations.
On the basis of note of
on the basis of all the objections of Punjab.
Mr. Kapil once said that there's a distilled lesson the Attorney General was able to produce for a lot.
And we were also asked, look, make concessions. We agreed to all that. Now you can't be reopening all this.
When question of settlement comes, then give and take has to be there.
Yes. Anyway, therefore, ultimately a decree should be passed so we can have it executed. That's all.
These are all factual. These are not. And leave it to your lordship. Having said that,
There are lots of facts that.
All these facts.
Wherever Malad your
Issued by
lordship wants.
learned attorneys.
30 years, I think, is a wrong calculation. It must be 15 years.
No, even in 2020, Mr. Venugopal said, let it be 30 from now. I'm just saying that.
I mean,
but I
younger
leave it to your
attorney
lordship.
general.
Whether 15 or 18 or 20 or 25, I leave it to your lordship. I'm just paying.
Yes, I can't say that. Pass the order. It's not right. They said you consider, you can't say that.
Please.
Obliged, man.
Very well.
It is an election petition, will not be lodged in the High Court. My lords, we are pleased to direct us to deposit 5 lakhs, my lords, which we have deposited. To issue notice to the respondent, my lords, your lordship directed me to deposit 5 lakhs, my lords, deposit, which we have done. So, my lord, notice may go to the respondent. Notice may go to the respondent, my lords, winning end.
Because we have deposited that money, you better issue notice now. That was to consider whether notice can be issued or not.
It's an appeal. It's an appeal, my lord. There is no, your lords may kindly see, as per the judgment of this honorable court, my lords. My lord, since it is an appeal, the 2005 6 SCC page 81. My lord, when your lordships, initially your lordship may kindly recall, my lord, I relied on this 2005 6 SCC page 81. My lords. No.
You get back 5 lakhs.
No, your lordship may kindly see, my lord,
The
2005.
other eventuality listen and then take the call. If notice is issued and then we dismiss, you don't get back any. You lose both.
No, let me lose it, my lord. Let me lose it. But it's I am confident about succeeding.
He's not doing anything in the meantime. Mr. Hon'ble, what is Hon'ble basically?
My lord, see, your lordship, my lord, I refer to 2005 6 SCC page 81, my lord, para 16. Only after getting convinced, my lord, by their judgment, you will also pleased to say that we will issue notice provided you deposit this amount. We deposited.
Okay.
No case to interfere with the implement order is made out, especially the civil appeal was so dismissed. Or the amount was 5 lakh deposited by the petitioner with the registry.
Let's.
As it is reported with 16th May 2025, may be refunded without any interest.
Minutes, may I know minutes? Only 1 second, you will kindly permit me to say this minutes.
Yes, Mr. Augusto.
Minute, I could not hear minutes, your lordship is dismissing it minutes.
We have dismissed the.
No, minutes, then in which case I will argue. Minute, I will argue on merits minutes.
This is what we were saying that you argue.
Minute, I will argue on merits. You lordship kindly see. You lordship kindly consider. But my case is minute that there was a criminal case pending against him, which has to be informed minutes in the affidavit file. Failure to disclose the same amount of corrupt practice and therefore on that ground minutes, the election can be set aside is our ground.
Now, urging the election field to fight, you are good politician both.
But in a criminal case, there was a closure report. Then
No, closure report was filed, but it was not accepted by the court. But we are contesting, we have filed, it is still pending, till today it is pending, it has not been accepted. If closure report.
One thing, the requirement of law is a pending criminal case.
Yes.
When a closure report is filed, the criminal case goes into suspended animation until and unless the protest petition is accepted and directions are given either for further investigation or to file a complaint and cognizance is taken on the private complaint.
May I respond to this?
Closure report itself is not accepted and a cognizance is.
May I respond to this? Lord, may kindly permit me to respond to this. There was a closure report filed. Notice has been issued to us until it is accepted.
Mr. Nagamoto, it's not a question of what is the legal impact of the closure report.
Yes.
Vis-a-vis the continuation of the criminal proceedings.
Yes.
It is a question of bona fide disclosure by contesting candidate.
Milord, it is not, Milord, law does not require, Milord, it is not closure by the police, Milord, closure by the court.
Correct.
Milord, until accepted by the
We
court, it is
have-
pending.
We have no dispute over the interpretation that you are giving
Yes,
to the police report,
yes.
praying for closure. But what we say is, if a candidate does not disclose a case on the ground that the police has prayed for closure, will it be said to be a dishonest suppression of fact?
Yes, it
which
is
a
suppression, but
corrupt
I got
mistake?
judgment to that effect. Milord, it is suppression.
Understand the collateral proceedings independent of the criminal proceeding.
Milord, it is suppression, Milord, it will vitiate.
Consider it from an employer-employee relationship.
Milord, may,
Pending criminal case, there is a closure. The person says there is no pending criminal.
may I submit, Milord? Milord, I have filed a compilation. Milord, it will take some time also for me to elaborate, Milord. I got a case. You will may kindly even have it tomorrow. I will elaborately argue, then you will, Milord, it's a very sensational matter. Milord, I filed the compilation also. Milord, there, it has been, Milord, my humble submission would be, Milord, Milord, so if earlier, Rule 26, Milord, said that if only in a case where cognizance has been taken and charges have been framed, Milord, it is to be disclosed. Now, Milord, after the judgment of this honorable court, rule has been amended. Now, Milord, as per the amended rule, FIR number with name and address of the police station used to be mentioned. Milord, FIR is still pending. So therefore, there is an arguable case for me. Not make,
we can't ignore that you want to, by raising these hyper-technicalities, you want to depute a elected candidate. He has won the election against you, and now you are creating all kind of sorts of.
Milord, your Lordship, kindly recall, Milord, in the recent judgment, Milord,
Now,
of Honorable Justice Mishra. Milord, where, Milord, that Meenakshi Natarajan's nomination was rejected.
Yes.
Similar facts. Therefore, my humble submission, I will refer to everything, Milord. I will refer to the law. I will make a detailed argument. Will not kindly have it any day subject to my Lord's convenience, Milord, in NMD.
What do you today? What do you mean by written arguments? Every time this kind of arguments being based.
No, I will argue. Otherwise, Milord, you please allow me to take your Lordship. Otherwise, your Lordship may kindly be pleased to permit me to take your Lordship through the judgments, the compilation, which I have not done. Your Lordship may kindly permit me. Milord, I will take your Lordship through the compilation. I will make out a case, Milord, that it is a suppression by him, and therefore it vitiates the election. It is a corrupt practice. I will explain. And your Lordship may kindly, Milord, your Lordship are summarily dismissing the appeal, which is, in my humble submission, Milord, with great respect, Milord, it is against the judgment of this honorable court in 2005, 80 SCC, page 81. Milord, when at the first instance, Milord, when the matter came up, when my Lord was pleased to make an observation that the matter deserved to be dismissed at the threshold, Milord, I cited this judgment. Only after going through the judgment, my Lord was pleased to issue notice, pleased to say that.
To give us the judgment which you want us to go through, we will go through definitely.
But on the compilation. For a 16, Milord, page 11, running page 11, Milord.
Yes.
It is thus clear that the upper courts, including the High Court, do not have power to dismiss an appeal summarily. Do have power to dismiss an appeal summarily. Such power is inherent in appellate jurisdiction. The power to dismiss summarily is available to be exercised in regard to first appellate appeals subject to the caution that such power will be exercised by way of exception, and if only the first appellate court is convinced that the appeal is so worthless, raising no arguable question of fact or of law, as it would be a sheer wastage of time and money for the respondent being called upon to appear, and would also be an exercise in futility for the court. The first appellate court exercising power to dismiss the appeal summarily ought to pass a speaking order, making it precise that it did not go into the pleas of fact and or law sought to be urged before it, and upon deliberating upon them, found them to be devoid of any merit or substance, and giving brief reasons. This is necessary to satisfy any superior jurisdiction whom the aggrieved appellant may approach, that the power to summarily dismiss the appeal is exercised judicially and conceivably by way of an exception. Now, my lords, in this case, my lord, I will argue, my lord, as to how, my lord, there are arguable points. My lord, your lordship may have to give a detailed judgment. My lords, your lordship may incidentally come to the next judgment, my lords. My lords, 2015 3 SEC 467. It starts at page 94. My lord, at page 145. 145.
Yes.
My lords. Paragraph 82, my lords. Last 6 lines. It is apt to note, my lords, your lordship has it in paragraph 82, my lord, last 6 lines. It is apt
To note here that when an FIR is filed.
yes, madam. It is apt to note here that when an FIR is filed, a person filing a nomination paper may not be aware of the lodgement of the FIR. But when cognizance is taken or charge is framed, he is definitely aware of the said situation. It is within his special knowledge. If the offences are not disclosed in entirety, the electorate remain in total darkness about such information. It can be stated with certitude that this can definitely be called antecedents for the limited purpose, that is, disclosure of information to be chosen as a representative to an elected body. Then, paragraph 94, my lords, in the same judgment, page 151, 94.4. As a candidate has a special knowledge of the pending case, where cognizance has been taken or charges have been framed, and there is a non-disclosure on his part, it would amount to undue influence, and therefore the election used to be declared null and void.
The answer is in the paragraph in which you are reading.
Yes, yes. In our case, the FIR pending against him is very well known to him. Before the Hon'ble High Court, in the earlier proceeding, he said that I will disclose everything in the election petition. I will face it. That order. After this judgment, the rule was amended, the form was amended. After this judgment, earlier, cognizance should have been taken, charges should have been framed earlier. Now, after this judgment, the rule was amended. You ought to kindly see the original rule and the present rule. The present rule says that mere FIR is to be mentioned. The original rule, before this amendment was,
Yes.
the original rule was the following cases are pending against me in which charges have been framed by the court. This was the original requirement. If only charges have been framed, no, the matter used to be informed in the affidavit. Page 12 of the judgment is extracted.
Is the old form. Mr. Nagamoto.
Old form and new form, both are there.
Mr. Nagamoto, the threshold is cognizance.
No, not knowledge. Threshold is knowledge.
The knowledge of what?
Knowledge that there is investigation going on. There is a case.
Of a criminal case where cognizance has been taken.
No. That was the original position. That was the original position before the amendment.
Original position was framing of charge.
Original position was taking cognizance.
No, sir.
No, it is there. You will not kindly see the original. Original position was?
Original rule was framing of charge.
Yes.
After PUCL judgment, as you rightly say,
rule
amended.
Yes.
FIR of such cases where cognizance is made.
No, it is not like that.
Well, that is like that.
You will kindly have a look at it.
Like that,
No.
if you read,
No, with great respect.
read Roman 4 of PUCL.
With
Roman
great respect.
4 of PUCL, the two questions of your compilation.
With great
Page
respect.
86. Page 86, paragraph 115.
This judgment, after this judgment, my lords.
This is the sheet anchor judgment.
No, it was, amendment was independent after getting clue from the judgment.
Read the amendment. Amendment is
Yes,
more
you will
clear.
kindly see the amendment.
Amendment says starting point is cognizance.
Amendment, may I read the amendment?
Yes,
The following criminal cases are pending against me, that is all.
Correct. What
Other
is the
things have been
criminal
removed.
case?
Other things, charges framed, cognizant taken, all have been removed now. Only criminal case is pending. That is the amended rule. Now, when the case is pending,
When a case is
column
pending in
table
a court-
says, table says,
When a court
FIR,
When a case gets pending in a court by registration of FIR
not pending in,
or by taking cognizance.
Your Honor, kindly see, it is not pending in court, has been removed. Pending in court, pending in court was the original provision. Now pending in court has been
Original
removed.
position was framing of charge.
Now, framing of charge, Your Honor, kindly see, now rule is, Your Honor, kindly see, the following criminal cases are pending against me, that is all. What is the case pending? It says FIR number with the name and address of police station concerned.
Very good.
That is enough.
No,
This,
sir.
here
Don't
he
read it
says,
disjunctively. No, don't read it disjunctively. See the other clauses.
I will read that. Table. First, FIR number
FIR number.
with the name and address of police station concerned. It is a first requirement. Second requirement, independent requirement. Case number with the name of the court. If, no, I am saying this. If this is to be, if, case is pending, if already cognizance has been taken,
Not agreeable to this.
if cognizance has been taken already, that is to be mentioned in column 2. Otherwise, it is to be said, no, that is all. Then, section.
One argument we are accepting, that instead of dismissing or appeal, we will pass a detailed order, but then don't expect refund of the amount. Now that we will impose that cost also. We'll pass a detailed order. Thank you very much for enlightening us.
Item 27 was
Your
that.
Honor, kindly, because the law be settled, Your Honor, kindly give a law. Your Honor, please to give a detailed judgment. Let the law be settled. There be no confusion in future.
Give a detailed order.
But for having Mulad's help, the law to be settled, should I lose 5 lakhs? Your Honor, kindly consider. Your Honor, kindly settle. In future, there will be no argument if your lordships are going to hold today.
You
So
donate
mere FIR need not be mentioned.
You donate it to indigent litigants who will be helped not only by the settlement of this law, but financially. will finance-
I can't say anything. Mulad.
You can't say anything.
I can't say anything except Mulad, plead for return of the money. Mulad, as instructed to me by my counsel.
Let us do like this, we're dismissing this SLP. You get back your money. Yeah, it is return the money.
No. My lords.
Short order with refund, long order with no refund.
Take back now.
Tell us what is to be done.
My lords, we are interested in the law being settled. We are interested in law being settled by your lordships. Let there not be any confusion in future.
Anyway, order is
Law is
dismissal.
already clear, but if you want us to reiterate that law, we will do that also. We are saying law to our mind is very clear.
After the amendment, there is no judgment. There is no judgment.
But the legal position, we are very clear in our mind.
After the amendment, there is no judgment. Therefore, you lordships kindly settle the law. With reference to the amendment. After the amendment, what is the position?
Sometimes don't raise the argument only because the junior is insisting for certain things.
And he said, I'm getting some instruction.
No, you do one thing. We will take the next matter meanwhile. You go and consult them and then tell us. You have given us written submission. If you want, we will give a detailed judgment also. But then we will not refund the cost because then you must bear the, after you are taxing the court.
At times we are greedy. At times we are greedy, in expecting both to happen. We are greedy to law being settled and also for return of money. We are greedy. At times.
Both things will not happen.
I will, may take instruction and ask them to report to the Grateful.
So this is that matter concerning, so this is that matter concerning district judges from High Court of Karnataka.
Yes.
So Lordship has asked them, I have two submissions
Yes,
to
yes,
make, and I am, because I am usually, and usually I don't make such submissions. Your Lordship had asked the Karnataka High Court to come out with a solution. They have now, without even issuance of notice, filed a counter affidavit, without even issuance of notice, without giving any options. We filed 3 options or 4 options, say how it can be balanced. The Karnataka High Court has filed a counter affidavit without even issuance of notice.
Never in collision with anyone.
Most importantly, the person who has signed the affidavit on behalf of the Karnataka High Court is a party responded in person. This should not be countenanced. This behavior should not be countenanced.
I think this is something that
this is unfortunate.
Parmeshwar is taking.
No, I am not taking anything. It's an High Court. The High Court files an affidavit through a person who's a party responded in person, and he makes allegations saying that we material and distorted facts. This should not be taken lightly. Your Lordship told us, told them.
Reply, if you should also be aware, I think you must have represented some High Court. It's not that an officer of the High Court will draft a written statement, it is filed.
No, but that's
the system.
I understand, but to take,
Judges,
when your Lordship asked
system, there must be a committee of judges who must do everything. Officer is only because he is a authorized officer, therefore he assigned.
But he's party.
Don't take that.
No, he's party. He's a party respondent in this. He's interested individually in the outcome of this petition.
The Registrar General.
It can be anybody, with all.
I think, in fairness, my lord has suggested that the matter should be resolved.
Just sort it out.
The matter should be resolved. We have given options, various options, where there is only 2 persons, if at all, will be affected. All the others have either retired or have become High Court judges. These options should be considered by the High Court and the matter can be resolved, rather than taking an adversarial stand and suppression.
This is what Mr. Vaidyanathan we have been expecting, that both sides will not take it as an adversarial litigation.
Yes.
Mr. Ashokdar, you are presenting.
Yes, I was representing the High Court, my lord. Apropos to what Mr. Parmeshwar said, my lord, there is no question of taking an adversarial position because there are officers at the end of the day, my lord. And this was only placed on record to demonstrate, and this will help in, my lord, finding a solution to demonstrate, according to the High Court, my lord, there was no excess appointment beyond quota, only that. Now, we may be right, we may be wrong, your lordship will determine if there is no solution. But I must also place on record only one thing, my lord, and your lordship would recollect that in 2014, when the 2008 direct recruits for the first time challenged, her ladyship as she then was, put a quietus to the matter in a particular manner, my lord, that judgment became final. So whatever was the cadre strength according to us,
the matter.
okay,
Don't interrupt.
whatever was the cadre strength, my lord, we've taken it from there, no one is disputing. The lordships were required to see is, because the ratio changed, my lord, because of the judgment of All India Judges Association. In 2005, it was 50, 25, 25. In 2010, it became 65, 10. Now it's again reverted back, and therefore, because of this back and forth, earlier it was 2/3 1. So what I was suggesting, as Mr. Vaidyanathan said, and Mr. Parmeshwar also, they've also filed on 21st minutes what they think should be the seniority list. You can go back, sit together and solve it.
Very well.
I'm not going to get up here because these are our officers and say, no, thing can be given to someone, surely. We won't come in the way, my lord. So your lordship may actually, my lord, it will help. Your lordship may fix some date because there is some kind of this, why should I call him, we are colleagues, that kind of thing. Your lordship fix it.
Meanwhile, you yourself examine.
Yes.
And what can be the modality?
Yes.
And what possible can be.
Very.
Maybe that their grievances also you can independently look into.
Yes.
And
we'll see. So would your lordship just fix it because our
after 2 weeks
and our side to matter and then some date, and maybe the justice's intervention over there will also help.
Lords, while this exercise is being done, one subsequent development will have to be factored in by all concerned, which is the 3 respondents I represent have since been elevated. Lords,
We have said we have no grievance against them.
I'm just.
We have no grievance against
I know
them now.
that the High Court is aware of it.
No, it
That
it was pointed out.
Last time also we said, those who have retired and those who have been elevated, there's no question of pressing this litigation. There's no question of pressing this litigation.
Although the principle is the same, but it's good that they're giving up on those who have been elevated, at least.
In their objection to the provisional list, their stand was that limited departmental competitive examination purposes are in excess. But in the writ petition, not a single LDC was made a party. Therefore, my lords, and their say was, it will have a cascading effect. In a post-based quota, the question of cascading effect would not arise.
We are not hearing it on merit today. We are only trying to explore that Mr. Rajiv Shabdar himself has been this side also.
Yes.
He knows better than us. Now on this side, let him examine independently and revert back to us that if need be, then we will adjudicate it.
Very well. We have given 4 options, we have put it on paper. We have the list according to all 4 options, we've given it to them, we have put it on paper also.
I'll call Mr. Parmeshwar, because we work together and I know Mr. Parmeshwar is
What
there
you say is,
he's sitting with me.
post will go out of
The
the
committee.
cadre. Therefore, all 32 promotees will have to be pushed down. But there is a finding. There is a finding under 65% of 32 may be affected.
Our suggestion will be that they have given 4 options. You have a right to disagree with those, but you can give your own options also, that these are the actual options available. And that both sides options may be considered by Mr.
Arguing before the French High Court. I specifically filed a chart also appearing for the promotees that they agree that excess appointments have been made under LDCA quota. But unfortunately, no prayer is sought against them. No LDC is made a party. Therefore, this is a futile writ petition, and High Court would not issue a writ against persons who are not parties before it.
This is all merits of the matter. I don't know why they are getting into this now.
Point very well taken, but we want to take it to a different level
I
where the High Court, as an independent partial arbiter, will sit with the 3 categories and sources of promotees, ordinary promotee, LDC, and the direct recruits, and try to work out a solution which possibly to the satisfaction, if not to the satisfaction, to the maximum accommodation for everyone.
Not to the entire satisfaction, to the some satisfaction.
Accommodation of every aspect.
VT conserved, we are going back.
We are exploring that part. We don't want officers to be litigation unnecessarily. You please give your options and your suggestions also. Consider those and come back to us.
Heartburn
Yes, every court.
in this order.
Your lordship knows.
See to it that
Yeah, I'll call Mr. Parmeshwar, Mr. Vaidyanathan, and all we can sit together and do it. I have no problems.
But we have filed a draft, Lord, seniority list of 4 modes. Lord, any one of the modes, Lord, can be solved, Lord.
all right. Yes, sir.
Perhaps seniority list may not help, but reasons may help. That why
Yes,
any
my lord.
ex-fighter or why a promotee or a director should be placed.
We have done that also.
Given 4 options.
We have done that also. We have done that also. Even the reason.
So also, sir, give your option, which according to you, like maybe maintenance of the list itself.
Anyway, I will tell before the committee.
But 3 judge
Don't want to
benches.
tell anything now. Here.
Your question of LDC not being heard may be addressed as a post-decisional hearing before the High Court.
But no LDC is recruited during their time. No
No
LDC is
LDC.
promoted.
In their
That is what
objections
for
against
93
the
the draft
provisional list,
seniority
that
list.
was their contention.
No, my lord. No LDC is recruited at a time. We have produced that also, along with the draft seniority list.
All right, we will consider that.
Yes,
First, Mr. Shabdar may consider, then we.
Yes, your lordship may have it after 4 weeks or so.
All right, after 4 weeks on Wednesday.
Very well. Great.
Item 28. Yes, Mr. Nagar.
I got instruction to
He thought that you are going back to fight the election.
That's, money may be returned, it may be dismissed.
First order. Again, persuasive power of Mr. Nagamuthu is prevailing.
But outside the court.
Outside, he has been persuaded. Now
That's what I said.
persuaded.
Grateful.
Item 28, we will,
But this concerns theft of large.
we'll take up after that matter.
Yes, so your lordship may tag it with the.
No,
other
no, no, no,
matter.
Malaj, this is, where is the question, Malaj?
Yes.
He cannot seek a direction for an FIR to be lodged. How can he seek? This petition is not maintainable.
Definitely.
That's why we have not issued any notice.
Yes, exactly, Malaj.
So, my lord, in the other PILs, which also concern KG Basin block, your
In any
lordship
case,
has put it on 27th of October.
This matter.
No,
can
this
call
is
CJI
independent
to the
of
matter.
those.
We are already.
Exactly, exactly.
Independent of this.
Yes, your lordship may have it
Notice
after
notice
that.
to be issued.
Obliged.
Yeah, no?
Item 29. 30.
So 30 is the denotification of the, it might take some time.
Malaj, my application on this has not been listed, Malaj. We wanted to withdraw but that's
That-
not listed. So
That
that
we are opposing, Malad, that's.
item 30, Malaj.
That may be
State
listed.
of Karnataka has filed an IA, Malaj, which is not listed unfortunately,
There are some
which is
applications.
IA number 209844 of 2024.
Yes.
So when the matter is listed, this IA be listed along with it. That's all.
IA number, the registered directory list IA number 7474 along with this case.
IA number? No, 209.
We can list then this matter on some other date.
Yes,
Just
Malaj.
one submission, Lord. Gail has sought and filed an implead application that may be allowed, Lord. Yeah, Lord, Gail has
No, no,
filed
no.
implead
Malaj,
application.
we have objections to all that,
24,
Malaj. We have
9.
objections to all that.
That may also be listed.
We will hear then all the
Yes,
applications.
exactly.
Any date may be given.
That's okay.
I filed IAs in the same matter. Those may also be taken up with this.
All pending IAs.
I'll give those numbers in writing.
That IA
I'll give
and
those.
any other IA. Will be listed along with the main case on so and so day.
Nothing much to do.
Item 32.
Item 30 में आएगी लिस्ट पे निकल ट्रिपल साहब ने यार ये
Get along with the what.
Lord, I'm seeking a pass over. My senior is on his legs before another court.
Another date. We didn't agree, no?
32.
We can list it on the same day along with the same day separate.
No, 32. I am in 34.
Yeah, yes, sir. We'll.
Because last order said that from the for order of May 26. Charge sheets have been filed at serial number.
Your lordship, sir, on 30.
Whereas the investigation in the
33,
main case was ongoing. And then you said a status report will be.
This is 32 or 33, Malaj?
33. 33.
Oh, I see, okay.
Oh, 32 is over.
32, your lordships.
All the others will be listed together.
32, Mr. Sibal, there was another petition on the 30,
Oh, I
Article
see.
32, covering the same. So we have posted it on.
Obliged.
Very
Deeply
good.
obliged.
So
Yes, yes, yeah, I know, I'm aware of it.
33, my lord. They were to file fresh status report.
Lord, we have the status report, my lords. We can, my lord, hand it over your lordships. May like to, my lord, examine it.
And my lord, they
This
they
is
should
by the
also, they
enforcement
should also
directorate.
file the charge
Only a
sheets
minute, only a
before
minute.
your lordship, whatever charge sheets they have filed, because two things need to be seen. Whether they have examined the role of the top management
This is what it is.
of these companies.
Mr. Bhushan, only a minute, give me a minute. My lord, this is for ED and this is for CBI.
Your lordship may go through these to see whether they have examined the role of the top management of these companies.
Well, that's top management is number only one person, right?
So we have examined top management.
He's only concerned with one.
Through these reports.
Yes,
and
yes.
take a call.
Yes,
Fair, fair enough.
There are two status reports, one by the CJI, One by CBI and other by ED.
Enforcement director.
One by CBI and another
One by ED, Manoj.
The enforcement directorate have been filed in court. These same are taken on report. Post the case on date for further consideration. Further consideration.
Please, sir.
Next one, a non-miscellaneous date, this is Wednesday, Thursday, or occasion.
I am applying.
The reports are, the residence will be on.
Lord, an item.
Item 34, there is a letter.
There is a letter.
Item 35.
My lords, pursuant to my lord's last order, Mr. Anand Grover, my lords, he had filed that impleadment application. He is also on record, my lords. My lords had given him the liberty. And the next date, my lords, before the Kerala High Court is the 3rd, and the Hon'ble High Court has given a strict indication that that will be the date for final.
Decided or pending?
My lords. On the 3rd of September, please, my lords.
The judgment is not.
Yes, my lords.
So I think better we wait for the judgment.
My lords can very well wait, my lords.
I
moved an impleadment.
We are informed that in terms of para 3 of order dated 17 July 2026, the Kerala High Court heard the matter.
It is fixed for hearing.
Also, fixed for hearing. Okay. That the High Court has commenced hearing. Then say post on so and so date.
Which would not include.
Await the outcome of those proceedings. Now, there is an application by who has been filed in medical
Impleadment.
there is application by Dr. Biju Datta.
I'm appearing for her. But she's in a similar position where again, she requires a particular drug that is only manufactured as of now in the US.
Let we will allow you to assist us as an intervener.
Great.
Yes, once is allowed to permitting the applicant to assist the court as an intervener. Post the matter on so and so date.
Prabha has said.
36 is an interesting question of law, interplay between
Yes.
insolvency court and
Whether the personal
and
guarantors
negotiable
get the benefit
instruments.
of the court. These are batch of petitions and conflicting.
The moratorium will apply.
Apply.
Yes, according to us, negotiable instruments act proceedings are quasi-criminal in nature and therefore may not, it will continue. That's our.
List on a Wednesday.
My
lords, I'm appearing for 36.5. There's an issue of law that we'd like to also get addressed. Liberty to file an additional affidavit to 36.5.
My lord, my my lord.
36.10 minutes.
Because my difficulty is.
Post the matter for hearing on so and so date. The parties, liberty is granted to the parties to file their additional affidavits, stroke complete the pleadings.
May I make a request?
I'm in 36.1. I'm for the respondent. My lord's wide order dated 9th March 26 had directed that the proceedings will continue. However, the petitioner number 2 in 36.1 has obtained stay from the High Court. My lords may have the outcome.
He said, continue, no.
36.1.
I'm in 36.1one.
Because in fact,
My lords, I'm for the respondent. However,
Go and approve the High Court and get a
my
vacation.
lords, but in contempt of this honorable court, they have obtained the stay.
How do we know that in contempt?
My lords,
If there is a disclosure of the order and on a different point, the High Court has granted stay?
my lords, because they have stated that, my lords, that's why I want to show this order.
Go and help the High Court to get this order corrected. Get the order vacated.
My lords, because they have made a statement that they are not the full-time director, whereas they have not made
So
any
that
such.
issue is not pending here. That's not pending here. That's a different ground on which the High Court is granting stay.
However, they have taken plea before this honorable.
My lords, in 36.12, my lords, they have concealed that they have filed a similar writ in the High Court and that's stand dismissed, my lords, and they have not even mentioned an iota about it.
Please on record, please don't keep the documents with you. We are granting liberty to the parties to complete pleadings to place on record additional affidavit. So if the document is in your hand, you will not be able to see. Whatever you want.
They have concealed, my lords.
30.10. Well, just one indulgence. Well, we file
Grant me
everything.
liberty to file counter. my lords.
What they are doing, they got a
Everyone is permitted to file.
Meanwhile, the parties may file their counter affidavits, so additional affidavit, complete the pleading.
Grateful, my lords.
Minutes 36, minutes 36.1 is me. I don't know, we have no instructions that somebody else we have approached to the High Court.
That's okay, we are not
36.
considering about that, what is.
Let them come up with their counter, right? They will know.
Will be filed, we will come to know, then you only.
Minutes, my only prayer in 36.1 was a no coercive action because the trial in Ludhiana court has been on.
The order is there, the order persists, right?
The order is there.
It continues, my lord. It continues.
The order got modified later on that subject and the proceedings will
Yes, the
go on.
proceedings will continue.
I am appealing point one.
Final order will not.
No coercive action till the judgment.
My lord, what is happening is the Ludhiana court is putting up the matter
My lord,
every
in
third day.
36.1, my lord, I am
We want the
appealing, my lord.
petitions to be recorded.
Correspondent
Don't
number
you
9,
think
my
we are
lord.
unhappy about that.
My lord, my only concern was the.
My lord, I have even withdrawn the
The law
complaint, my
says
lord, that
6
is being
months.
filed by the petitioner,
We
my
are
lord.
trying to,
My
we
lordship,
have
in
appeared, everything is done. The only
you
concern.
get
Convicted, then we'll satisfy the conviction.
My lords have protected
Lord, in
us to the
36.1,
extent of
my
no
lord.
coercive action, subject to judgment.
36.
It's not a coercive action.
Absolutely, my lords.
Sending you to jail is a coercive.
Coercive action. Absolutely, my lords. My lords have been kind.
You also be 36.
There was a confusion whether filing of a charge sheet is a coercive action. Somebody did file a petition
Yes.
that this is contempt and the default bail provision was kicking in.
Yes.
Because they also don't deposit the money is ordered by the trial court. That's also a difficulty. The 10%, 12%, they say no coercive, so we won't deposit. That's happening in 36.10.
Grateful, my lords. Obliged.
Lord, in
Obliged.
36.1, my lord, I am appealing for respondent number 9, my lord.
I beg to appear for the petitioner.
My lord, I have withdrawn the
Lord's
complaint
matter
petition, my lord,
has to be
which
referred to an
filed
arbitrator,
before
my
the
lords.
court, my lord.
I appear for the
I have
respondent, my
even
lords.
annexed the copy of
We are
the
also
order, my
agreeable
lord.
for that. I would only, since it has to be a court-appointed arbitrator, I would only suggest the name of Honorable Justice K. Kannan.
Kannan.
Kannan he wants.
Justice Kannan.
Yes, Honorable Retired Justice K. Kannan of the Madras Circuit and the
Honorable
Punjab.
Justice R.K. Jain.
Case is from Tamil Nadu.
Kannan.
My lords, or Honorable Justice R.K. Jain, my lords, or any
For that, my lords, subject with utmost.
In the name that he is.
Please, my lords, because this is an Australian entity, let it be.
Yes,
any,
they are an
any
Australian
party,
entity.
My lords, let it be before DIAC if my lordship.
So, my lords, this party, the respondents are
in
based in Coimbatore. There
36.1,
may be
let it
some
come on
language issues
record, my lord,
also. Of
that I
course,
have
it's an
withdrawn the
international
complaint,
commercial
my lord.
arbitration. If at all my lords are agreeable and the other side is also agreeable, for Honorable
What's
Justice,
the seat? Seat for arbitration?
it has
Because
to
it
be
says in India.
It's domestic only.
Yes, yes,
India.
So,
India.
Where is it, Madras?
My lords,
Madras.
One party.
my lords, one
You're,
party
you're
is in
from Australia.
Australia.
Madras is nearer than Delhi.
My lords, we both are before the Supreme Court. So, my lords, let it be here in Delhi. My humble submission would be let it be here in Delhi.
Madras is not.
No, my lords, because this is with respect to export, my lords, export and import. So, my lords, my humble submission, if it is before Delhi, my lords, I can only beg.
I only submit, my lords, there is some dispute. Of course, the dispute cannot be gone into by this court. Only to that extent, I say it will tend to the general convenience of the parties. They may be very permitted to join online also. The company is based out of Coimbatore in Tamil Nadu.
What is the difficulty if the, somebody is appointed in Delhi?
So, my lords, the thing is, even I am not conversant in the language in Tamil. Let it be there, my lords. If there are any practical difficulties also, it may be taken very well care of there than here. Let the ball be out of our courts and let it go there. It's in the party's best interest is what I say.
There's no question of any local language being involved. It's export of vanilla beans.
All right, we will appoint someone.
From Australia.
My lordships may take into consideration the name suggested by us, by both the sides.
Grateful, your lordship.
Grateful, my lords.
My lords, I'm appearing for the petitioner.
Also after notice.
After notice, ladies.
Service is complete.
Service complete. I believe appearance has been entered by the respondent.
You are
Yes, Lords.
Counter affidavit also.
Yes, my lords,
Yes,
I
Lordship.
appear for the respondent. I need to make a very short submission, my lords. My lord, in this, when the notice invoking arbitration was issued, it was issued in the name of a non-signatory, my lords. My lord, I'll just request my lords to come at page 16.
These are all issues to be gone into by the arbitrators.
But my lord, non-signatory invoking matter, the pre-reference stage is my submission, my lords.
Fox and Kings and all these things, sometimes non-signatory also can be.
My lord, I just one para, my lords, if my lords would want to see, my lords. Sir, ye judgment de dijiye. Just one parameter. After that, I'll leave it to Malats. And Malad, it's why this MOU new incoming partner has been inducted, Malad, and there's a no separate partnership deed also. So entire thing goes, Malads. MOU says, I'll just request Malads to come to
What is it?
para 33, Malads. Internal page 7 to 9, para 33. Can I read, Malads? Para 33.
What is the relation between the non-signatory and the signatory?
But they're husband and wife.
They have a commonality of interest.
But my lords, no commercial interest has been established, my lords. In this, I can impute all my relatives in an agreement, my lords, who was not the party, my lords. But I'll just read para 33, my lords, 33 and 34. In fact, ASF Buildtech expressly notices the holding in para 169 of Cox and Kings, to what my lords referred, that the referral court was required to prima facie rule on the existence of an arbitration agreement and whether the non-signatory was a veritable party. All that it holds further in reiteration of the earlier line of the judgments is that even if a court holds that prima facie a party is a veritable party, that will not foreclose the arbitral tribunal from concluding to the contrary after an intent.
What we are pointing.
Yes, just one para, just one. I understood what fell my lords. Para 34. This does not mean that where the referral court finds prima facie a party is not a veritable party, still the matter is left to the arbitral tribunal.
We are saying the converse. We are saying even assuming the notice is issued to a party who is not a veritable, still the tribunal has the earlier para. The converse is given in para 34.
Yes. So what I am submitting is even the referral court has a prima facie can look at whether this party is a veritable party or not.
Nevertheless, the tribunal can also look.
Definitely.
What is that mean?
Yeah, I will not dispute that.
How much is the dispute?
About 50 lakhs, Lodge.
About 50 lakhs.
Yes.
In Delhi only?
It's in, venue is Pune. Pune.
Pune.
Malad, can I come? But just one more issue, Malad.
Yes.
Malad, this arbitration agreement, the arbitration clause is provided in an MOU where it is said a new partner is being inducted and a supplementary partnership deed will be executed. That deed was never executed. So that person is not a partner. And my lord, everywhere they've used the word partner, I just want to make it a point that party and the partner is the same thing.
All these issues can be addressed before the tribunal.
My lord, when partnership is there, the entire arbitration agreement goes, my lords. That is my respectful submission, my lord.
Let my learned colleague argue that before the tribunal. Let the tribunal decide on its own jurisdiction and the merits.
But all of this can be saved, my lords, my lords.
Some contentions will be left over.
Both the question whether there is an arbitration agreement between the parties and whether there is an arbitrable dispute, both will be gone into by the arbitrator.
The concluded contract, you mean to say? There is no conclusion.
My lords, if I may make a submission, I requested for a sole arbitrator. There was some issue which was raised by the opposite side.
There will be one sole arbitrator.
I
Retired district judge or some advocate.
Yes.
Obliged.
The amount is 50 lakh.
Yes.
Good.
Item 39, there is a letter. Item 40.
What Court Council is here?
Last time, my lords,
Somebody took time.
somebody took time saying that they'll file a counter last time. I think they filed something.
That was before, not after that.
Yeah.
19.
Last order was on.
Filed any?
Nothing.
Application
should be favorably considered. But your lordships, we've now been caught in a web of bureaucracy of approaching different authorities. So I have the various communications that we have sent.
We will be taking admission. You had taken the pre-KG.
Your lordships had said that I should apply for nursery. I have applied for nursery. But however, what is happening now is between the local authority, the state authority, and the school, they are sending me in circles, your lordships, about who has to take the decision for admission. So there are some communications, if I may hand across the communications that have been sent. There is a local authority under Section 9 of the Act, who is also respondent number 9 in this matter. Can I please pass this across, sir? Can someone please take? Thank you.
Subject to this, you have.
So,
You're appearing, who is appearing for?
For the state of Maharashtra, Ms. Rukmini Bhopre is on the.
Who is there?
Lordships, I'm appearing for the state.
if your lordships may kindly have page 2 of this compilation that I've handed across. This is the communication from my instructing lawyer to the school and to the education officer, primary Zilla Parishad. That's respondent number 9 in the present SLP, who is the local authority under the Act.
Yes, Ms. Bogde, what steps were taken by the state and the school with regard to the request for pre-nursery admission?
Lordship, I'll have to take instructions in this matter.
Take instruction. In the meantime, ensure that the child is admitted to the school to which she has applied for pre-nursery admission.
Which school are you asking for?
Your Lordship.
Bharatiya Vidya Bhavan.
Bharatiya Vidya Bhavan, Bhagwan Das Purohit Vidya Mandir.
And that this reservation quota.
Your lordships, yes, your lordships. They have RT. Your lordships, there was initially a rule in Maharashtra that it had to be within 1 kilometer. Now the Hon'ble High Court is in fact set to 3 kilometers. But the difficulty in my case was, so the elder child is in the school, but when I applied for the younger child, the residence we were in was dilapidated and needed to be renovated. So we had to move out. So when they came to do the inspection, they said, you're not actually living here.
So this kind of objection may come, that's why I was asking.
Yes, Your Lord.
Anyway, the court is passing certain directions.
I'm grateful, Your Lord.
And with instructions regarding compliance of order dated 10th August 2026. That's meanwhile, to the urgency for the child's admission to school, committee directed that the petition shall be admitted to the school where he has applied for admission. Be admitted to the school where he has applied for admission. The compliance will be filed.
I'm so grateful, Your Lord. So good. Grateful, Your Lord.
Yes.
I beg to appear for the High Court of Kerala. 22 millards, I may be granted a little time to file a rejoinder, millards. No, milord, only 2 weeks time to file a rejoinder, millards.
Para 1 of the judgment.
What do we want, Mr. Chidambaram?
No, you said the discussion. The High Court.
Just 2 weeks time to file a rejoinder.
I am here to receive the cost.
Transfer. Now.
I'll file a rejoinder, milord, 2 weeks time.
Land policy, the petition is granted 2 weeks time to file rejoinder post-mortem.
May it please your lordships. My lord's a very meritorious candidate, my lords. He stood 8 out of 1791 people in the examination, my lords.
New case made out.
My lords will see that I'm extremely meritorious, my lords. I've woefully low marks in the Viva VOC, my lords, which was conducted by an improperly constituted.
Which the point is that, please appreciate, the sitting High Court judges are conducting the.
That is right. May I just say this, my lords? There are vacancies. There were 101 people, 101
Point
vacancies.
is not a vacancy, point is of that if the candidate is, High Court doesn't find suitable, then what? we
But
have to prove?
the
For a suitable candidate, we can ask them to create a vacancy.
see that the legal point that I raised was that it was an improperly constituted selection committee. The selection committee, my lords, came after my lords.
Can you, Mr. Palli, can you consider something?
Lord, I have to take instruction on that. Lord, basically training is over. They have been sent to posting, Lord. Now, after 2 years, Lord, taking back, Lord.
It's not 2
And
years.
Lord, it will
Training
open
is
up.
still going. They've said in their counter that training is still going on.
Lord, now, but it means those who were there, list me, Lord. That will all come up, Lord, one after the other. Because what is 6 persons there in the committee? All the 6 unanimously resolved, Lord, majority will prevail, Lord. 4 of the members were there, 3 judges.
No, we are not impressed by this ground that because the Advocate General or so and so are not there.
But
No,
this
no
way,
prejudice is caused to the.
it will be unending process, Lord. Interviewing 500 persons, Lord, it would be.
My lords, a candidate is here. My lords, back, my lords, because he is
And this
very
is second
meritorious.
round, Lord.
Out of 1971, I got 513.
I'm not this second round, Lord. Initially, he came up with the Lord plea that this is the 506 is not, Lord, beyond the rules. Now that after Lord discussing that, his fresh interpretation is that law, the committee is not properly constituted. Lord, this
Let
is
them take
full
instructions,
committee,
my
Lord.
lords, if it's possible.
And that way it will never happen.
Candidate who will be lost to the judiciary, he is.
High Court, if the High Court.
There are, my lords, there are three orders where in similar situations, my lords have asked either my lords pass under 142 to grant where the parties where the person was meritorious. My lords, there is one in fact with respect to this
Lord,
same.
getting 50% marks, Lord. Meritorious is
There is a
saying
Diksha Council, who's in scheduled caste zone, my lords. My lords have directed.
Madam, please, Matthew, I
There are
think
3 orders.
we don't think that there is any direction bias for a candidate who is not found to be qualified candidate. For a qualified candidate, yes, there are certain occasions where we have been issuing directions. Here, unless you are again interviewed and you are made to qualify, the problem is there. We understand, we have full sympathy. What we can do at the best is make a representation to the High Court. We request the High Court to consider.
In fact, in the it's very same matter, my lords have directed the High Court to consider. Then my lords will then pass the same order, but it might be done in a month. Or my lords will see this order in Diksha Carlson.
Can I have a copy?
Yeah, please give me.
Because problem is in your case, it's not a question of appointment, it's a question of re-interview.
Re-interview, Lord. All those persons who were there in the list, Lord, they all have to be recalled, Lord. And then, Lord, to be honest, on 30th September.
Challenged. I'm the only person who is before court.
Okay.
There's nobody who had more marks than me who has not been appointed, my lords. The 7 people above me in the, my lords, will see page para 3. Para 4, my lords, we request the High Court to consider the representation sympathetic.
Reserve category candidate, only 9 were selected against 39 posts.
In this
So
case,
that's why we said High Court.
188.
Lord, here 455 candidates were there, Lord.
There are
455 candidates.
vacancies, my lords.
Lord, I would have thought not that, but 455 candidates who were interviewed, Lord, and recalling and interviewing, Lord, and then it is not on this particular, there were 4 persons, Lord, interviewing. Not because the interview went up from 30th September to 1st October. It is not 2 weeks, 3 weeks, they're all interviewing, Lord, it will be a huge.
Because my lords under my.
Not rank, I'm not only 50% marks was included in written test. 500 out of 1,000, Lord. That's saying not 8th rank or whatever, I have nothing against personally, but now it can't reopen the High Court, Lord. Twice High Court has gone into it.
How old is he?
And he has applied for Delhi also as per it.
Child. He's a brilliant child. You see, let's not demoralize him. Next time he will definitely make it. Earlier apprehension of these children was that their 3-year condition, because that on Friday we have relaxed that condition.
1 year.
Now he is already qualified. The moment now exam will be held, he will appear and he will qualify. We are 100% sure. Because sometimes first interview, children do commit mistake. I have also been interviewing candidates, hundreds and more than almost 400 officers I know that I have selected.
My lords had started off with the High Court. Let the High Court go back and seek whether it is possible, my lords. to
Merit was
accommodate.
declared twice, my lord. Twice has been.
Because my lords will see this.
There is a
See how
meritorious
how it
candidate.
tested.
You are getting a meritorious candidate.
Not meritorious, not saying meritorious, not 50% marks.
No other contenders.
Out of about 1,500 marks scored, my lord.
No.
Saying I was 8th rank, I was meritorious. That's why, my lord, in the interview, he couldn't, my lord, make it to be honest, my lord.
My lords could, my lords.
Not saying that meritorious and all that.
And my lords will be convinced about his suitability.
Commissioner has not been able to make it to the commissioner could not make it to the arena judicial services and record civil judge, record entry level. Due to the fact that out of 200 marks in Viva Voce, he secured only 29.75 marks. He performed well in the written examination, written in bracket main examination. The High Court wide influence judgment is justified in rejecting the petitioner's claim maybe for a pre-interview. In the absence of any legal error, we are also unable to interfere with the influence judgment. All that we can observe is that the petitioner may submit a representation to the High Court on administrative side, which may be sympathetically considered.
Much obliged.
The committee, the moment you will feel free, at least this much functioning we are aware.
Because this has not been decided as yet. That's why I'm saying.
So they will decide it immediately.
Lords will say in 2 months, my lords.
Much obliged.
It's not appropriate to tell the High Court to decide in a particular manner, but we are quite sure that.
Or expeditiously, my lord might just add expeditiously, my lords. Expeditiously may be added so that. Obliged.
Pleasure.
Correct. The satisfaction नहीं पर accord तो हो गया.
How much time it will take, Mr. Diwan?
Because it will take a little bit of time and I'm a little in an awkward spot because I'm on my legs in a parthard in another court.
Better, then we'll take up on some non-miscellaneous.
Yes, sir, you're right.
Because my only request is one, since your lordships, I'm instructed to say and indicated that in the meantime, let nothing happen in the arbitration. The arbitration is not proceeding. So any time that your lordships at the shortest can accommodate us is all that I can request, my.
You are sure. On a non-miscellaneous.
As I seek to mention. I seek to mention, if my lords permit, I'm so sorry. The matter before court 11 today, they did not sit, my lords. I requested the learned registrar for tomorrow. The bench is not there tomorrow. I'm constrained to mention here. And as I requested the registrar for tomorrow, there's an urgency. They said the bench is not there tomorrow, therefore I'm constrained to mention here, my lords.
So it was before court.
It's before court 11, my lords, but I have an urgency for tomorrow. Please, they did not sit today, and they're not there tomorrow is what I'm told.
Some family member got
Please, my lords. Would my lord please consider, my lords. I'm so sorry to mention while my lords are rising.
No, it's all right. Let us examine it and
I'm grateful, man.
if there is no extraordinary urgency, we can sit on.
I submit the urgency, man. This is a graveyard. There is a function data. They defile the graves. They dug the poles in the graves. They cook food over the graves. And I put photographs also in my SLP showing what happens. This is the urgency, man.
Really.
Grateful.